For judgment, item number 1.
The appeal is partly allowed. And you record the appreciation of the assistance rendered by the case.
Item 2.
The appeal is allowed.
Item 3.
The appeal is allowed.
Item 4.
Partly allowed.
Item 5.
Not partly allowed.
Item 6.
Allowed.
Obliged.
Item 7.
It's allowed.
Item 8.
It's also allowed.
Item 9.
It's partly allowed.
Item 10.
The appeal is allowed.
Item 11.
It's partly allowed.
Item 12.
The appeal is allowed.
13.
It's allowed.
14.
Allowed.
15.
It's partly allowed. And I record the appreciation.
Any mention after the list?
Any mentioning?
Item number 70. It will be taken off the hearing.
17.
70.
70. What do you want?
It will be taken off the hearing.
It will be taken up. If any adjournment, anything you want? Yes. Start.
Item number 37.
Hmm.
Kindly 1 week.
Why 1 week?
And let's say
37, which years?
I had received that brief.
2005.
Let's say received that brief. I had
Okay,
not.
next week. Next week. Next. 2005, na?
Yes, yes. 37. That is.
Okay. Start.
Item 16.
My lordship, item 16, I am appealing opposite party number 2.
Yes.
I'm asking practitioner and appealing party in person, sir, item 16. I'm just going to give the memo of party person, sir. My paper is on the way. Please allow me 10 to 15 minutes, sir, so I can prepare all the things, sir.
You want a passover?
Sir, please, sir.
No, what exactly you want?
Okay, within 10 to 15 minutes, my help supporting advocate is coming. on the
Okay,
way.
your lawyer is not there.
Yes, sir.
Passover. Okay. Passover.
Item 17.
Your lordship, 17.
Hmm.
I got the instruction that the person is not traceable, your source.
Not traceable, not traceable. Well, let us see, proceed with the matter. What to do? How many? You can't keep on searching. Yes, madam. What is this? What is the offense?
Simple and consider 3 months of 3 months and.
EC Act, Your Lordship.
EC. Let us do it. Finish it up. You're not ready. I'll pass it over this, chief. You can do it. No. Let us see. Yes.
To the complaint of condemnation of clause 3 of subsection subclause 2 of the Orissa Rice and Dairy Control Order 1965, which is punishable under section 7 of Essential Commodity Act also. My lord, the written notes.
Sorry?
Written note,
You have it.
yes.
Give it. Yes. Yes, madam.
YC of the Director PS was from the petrol duty at Delhi near Sarvati. He detained a truck bearing the registration number NP 26B2681 coming from Sambalpur side, crossing towards the Hon'Ble. The truck driving by the appellant Sibo Sankar Mishra, which was carrying 200 bags of cement and 35 bags of rice. Each bags weighing of about 1 quintal. The total weight of
35 quintal.
Yes.
35 quintal. Okay.
Driver for the transport 400 bags of cement, but could not show the authority of license for the transportation of the 35 bags of rice. The driver on the further query supplied, he knew that the rice belonged to the other two accused dealerships, the Kaneshwar Sahu and Mansuhan Rao, two other accused dealerships, who were also in the truck. However, they also could not show any document to back off the transport of the rice. A decision list was prepared on the spot. The truck was taken to the relevant police.
He said that it belongs to one Ganeshwar and Madhusudan.
Yes.
Okay. Whose truck? Who was the owner of the truck?
For the bags of cement were given to the chief of custody to Harish Kumar Tuli.
Harish Tuli.
Yes. And
Okay.
35 bags of rice were given to the Manohar Jaishwala Nela.
And during the investigation, this seizure truck was given to Harish Tuli, and rice was given to Manohar. Okay. Yes.
There are 4 prosecution witnesses were examined on,
Mm.
and 2 were independent witnesses. Both were direct to study. They stated that your lordship the
Independent witnesses are PW,
PW1 and PW2.
PW1 and 2 hostile. Hostile. Okay. Mm. Yes.
They stated that your lordship the article seems in their presence and that their signature were taken from blank papers by the police. That is their judgment. And your lordship, there were 3 accused, 2 were acquitted by on the spot, your lordship. After this, on the judgment, your lordship heard November 1995, but other 2 accused were acquitted.
Acquitted received. Okay.
Brahma lordship himself heard sentence.
No, but this man was sitting in the vehicle.
3 persons are there. And 1 is the driver, who is the appellant, your lordship. Other 2 persons were acquitted.
Those who were sitting in the
Yes.
Okay.
They were also accused and trial also against ARA.
Okay. Let us see now.
Yes.
PW3 and PW3 and 4 are the only 2 witnesses.
3 and 4 are the police officers,
Yes.
officials.
Hmm.
1 and 2 are the independent witness.
They
Those
didn't
are
support the case.
Right.
What stand you have taken? Only denial? Or you have,
The accused is not the trader, you know, is the carrier. Is not the clause that is, clause 3, section 2, which is.
have you laid any defense evidence or anything?
No,
Let us see now, 2 and 3. Let us see. PW1 is Sanatan Mahapatra. चलो ठीक है PW2 is Tezraj Kalta. Both of them reachable. Okay, let us come to PW3. Read it. On 10/4/1991, I was working as a SI police at he says that they were taking the said drug. On search, we found 200 bags of cement and 35 bags of rice.
The driver.
Cement, but could not.
the other two are accused also not also any kind of documentation regarding.
Who are they? Let us see, understand. Why she sees the truck and the cement? And presence of the witnesses and prescribed series and the so and so. Okay, let us see 4.
Driver saying that these two persons are right belongs to these two persons.
Ganeshwar and this he says.
Yes, sir.
What attempt you have said?
There is no evidence shows that this rice belongs to these two persons. Therefore, they are
What is your investigation?
our investigation is totally belongs to this driver only because.
But the independent witness says no seizure.
Independent witness only saying that in my front there is no witness.
Then what is the evidence? How have you
But he admitted.
waited?
But he admitted about that rice is there. The actual driver himself who is saying that the rice belongs to.
Where has he
these two
said? Where has he said?
persons. It is a judgment of page 5 पे लिखा है.
Let us see the evidence. PW3 I read it.
Lordship, the prosecution did not examine the two person to whom the particles were custodian.
Then they will say that it was onus was on you. It is a rebuttable presumption. You should have brought them to the witness box saying that yes, these rights belongs to me. Once you have admitted, let us see that. No, there were two. See, it says that there were two other inmates in the truck, namely Ganeshwar Sahu and Madhusudan Rao. See, PW4. It says that these two people, Ganeshwar and Madhusudan Raut, were also there. Then in that case, the co-accused persons, who are the co-accused persons? Who are the co-accused persons, madam? That's the same Ganeshwar and Madhusudan were also put to trial. They were acquitted.
They were acquitted. Yes.
Ah,
Benefit of doubt.
benefit of doubt. Then they were also there in the truck. He says that neither the driver nor the aforesaid inmates could validly account for the possession of cocaine. Thus, I seized the truck. Roller so and so. I then examined the witnesses and came back to the PS with the seizure material and the accused persons. Okay. $35 bags. And what is the weight?
33 quintals.
Hmm.
Exactly.
How, where it was weighted there in exhibit 4 says it is weighted in the police station.
3.39 quintals. Accused statement also. Question number 6.
Your stand is there was no seizure at all. You don't say that it belongs to Ghanshyam or Mono. Just see 313. You say ନାହିଁ ମୋ ଗାଡ଼ିରେ ଚାଉଳ ନଥିଲା ନାହିଁ ମୁଁ ଜାଣି ନାହିଁ
Even se 200 bags କଥା ବି ସେ କହିଦଉଛି ଯେ ନାଇଁ ଏଟା ନାହିଁ।
ଗାଡ଼ିରେ ଚାଉଳ ନଥିଲା ବୋଲି କହୁଛି।
ସେ ଯୋଉଟା
Last-
ଆଜ୍ଞା।
Last question is question number 12. Just read. You have heard
ଆଜ୍ଞା।
the entire evidence. What more you have to say? ମୁଁ
ଆମେ ଗାଡି
ରେଡା ଖୋଲରେ କଣ ଲେଖିଛି?
ନାଇଁ ଆମେ ଗାଡିରେ ସାର୍ କ୍ୱେଶ୍ଚନ ନମ୍ବର 12 ନା
ନାଇଁ ହଁ 12.
ଆଜ୍ଞା ଆମେ ଗାଡିରେ ନେଇ
No, ପ୍ରଶାନ୍ତର ପଢ ନା ଭାଇ, forget about the other two. ପ୍ରଶାନ୍ତ last ଅଛି ନା। ଅନ୍ୟ ଲୋକମାନଙ୍କ ସହିତ କଥା ହେଉଥିଲେ ସେ କେତେବେଳେ ପୋଲିସ ଆସି ଗାଡିକୁ Got it?
ଆଜ୍ଞା ଏସବୁ।
Read. ମୁଁ
ମୁଁ
ରେଡା ଖୋଲରେ
ଗାଡି ରଖି ଚା ଖାଇବାକୁ ଯାଇଥିଲି ଏରପର ଅନ୍ୟମାନଙ୍କ ସହିତ କଥା ହେଉଥିଲା ସେତିକିବେଳେ ପୋଲିସ ଲୋକ ଆସି ଗାଡିକୁ
ପୋଲିସ ଲୋକ ଆସି ଗାଡିକୁ
ଚାଉଳ ଗାଡିରେ ନଥିଲା ଗାଡିକୁ
ରୋକିଲେ
ହଁ।
ଚାଉଳ ଗାଡିରେ ନଥିଲା।
ଚାଉଳ ଗାଡି-
This is your stand. This is, you are not, you don't say that it belongs to Ghanshyam or anything. You say it was recovered. It was not there at all. Then the two officials says that it was recovered.
It was recovered.
And how these officials will be doubted, you tell me. It's not a small quantity, 33 quintal. Why the police will implant unless you say that there is some enmity or something? Nothing is there. Why
ତା
50?
ପିୟୁଷ ମାନେ there is other persons are also there ସେମାନେ ତ କିଛି କହୁନାହାନ୍ତି ନାଇଁ କି ପ୍ଲାନ୍ କରିଦେଲା ତ ସାଙ୍ଗେ ସାଙ୍ଗେ ଗୋଟେ
ହଁ,
ବସ୍ତା
but-
ପ୍ଲାନ୍ କରିଦବ
So,
and even for the 200
Equal.
bags cement ସେ କହୁଛନ୍ତି ତାର ପରମିଟ ଦେଖେଇଲା
hmm. Yes, madam.
Do I need some judgment? Next week.
Not next week. Thursday. Come with judgment. I see you have a difficulties. No, but let it try.
Yeah, yeah.
Day after tomorrow. Let it try. He may get something. Okay, next.
Item 18.
Yes.
Your Lordship, the paper book has not been issued yet.
Sorry.
Paper book has not been issued yet.
Paper will be never issued. You have to take it. Take the soft copy and get ready. See, these are the matter 98 matter. You have appearing for whom?
For D. Naik and Associates.
Then you get what are the offense?
Offenser, Your Lordship, 20B1 of NDPS Act, with section 47A of Bihar and Odisha Excise Act.
Yes. Sentence? Sentence? 6 months.
1 year errors 1 year and 2000 fine
Yes. Get ready, madam. You take the soft copy and get ready. Day after, huh? Day after.
Yeah.
Day after. I will not give adjourn it. No, I will not adjourn it. 98 matter. Otherwise, I'll appoint someone else and proceed with the matter. 98 matter I will not do. Please don't. Yes. 19.
Item 19.
Take the soft copy immediately today itself. 19. Pass over.
20 90 on that lot can you see
None appeared. None appeared. So
16/10/2023 so like I said it's not a court will happen
yes, Mr. Das. You can't escape from the court. You have to assist in this matter as amicus curiae. Take the file now. Mr. Das is appointed amicus curiae. Shall I put it on Thursday? Thursday or next Tuesday? Next Tuesday. Mr. Das is appointed. You give full name and your phone number also. Since consistently none had appeared in the matter and the last date of hearing, or that is on 16/10/2025, it was indicated that if none appears for the appellant, amicus curiae will be appointed. When the matter is called for hearing today, none appeared, therefore Mr. Das has been requested, who is present in the court, is requested to assist the court as amicus curiae. And he seeks 1 week time to get ready with the matter, release the matter also. And soft copy, Mr. Das, take the soft copy pen drive. Today also, today itself send your junior and take it so that, yes,
Item 20.
yes, 20. What else?
21.
Yes,
That's in this item, the offenses are 20B(a) of NDPS Act,
yes.
and the conviction is arrest for 2 years. But Lordship, in this contraband ganja amounting 13 kgs and
Yes, 15 kg and
the 13 kgs and 500 grams of ganja has been seized.
yes.
No, Lordship, it is under the commercial weight. It is under the commercial.
Under the commercial quantity, then you will get the bail only, not acquittal. You are not arguing bail. You are arguing for an appeal. Those arguments are for bail. How much he has undergone? Have you checked it, Mr. Das?
But see, after conviction, he has undergone for 1 month, 7 days.
Not 1 month. Just see the order dated
Again.
13/4/2007. It says,
Yes.
see, he was granted bail on 8/1/2007. ठीक है? And cash security of 25,000 something. He could not arrange. Therefore, he moved an application for modification. That was allowed on 13/4/2007. Means
4 months, 12 days.
almost 12 days.
Again.
And it is being independent, and NDPS case he might have been convicted for just check it up. Custody period must be little more. Item कितने
21.
Just see the charge sheet when he was arrested. Final form. What is his name? Name is
Jafar Munsi.
Jafar Munsi. 23/8/2003 arrested. What is that? 20 arrested है. Arrested 23/8/2003. ठीक है. Now see the bail. When the bail got order sheets, just see.
Lordship, bail bond, there's a bail bond on 26 September 2023. Sorry, 2003 Your Lordship. And PCR page 182.
He was granted bail on 15/9/2003. Bail
59, maybe, but the bail bond is in 26/9. Your Lordship.
15/9/2003. Bail bond?
Bail bond is 26/9. Your Lordship.
Bond 26/9/2003.
Bail bond
2003. So how much this then after conviction?
After
After conviction, taken into custody. Okay, judgment is on.
After conviction, there is 4 months, 12 days.
No, after conviction, no, it gives the date of judgment is
Date of the 1/12/2006.
judgment है judgment 1/12/2006. 2006. And bail on
Bail on 13/4/2007.
13. No, first bail 13/4.
13/4.
4/2007.
7.
So then it is about 5 months.
4 months, 12 days.
Bail. The bail bond, when has he filed bail bond? Have you seen it?
Now, bail arrest on 23/8/2023, bail bond on 26/9/2003.
No. After this
Conviction.
the bail bond is there. Whatever, then during trial he has undergone from August to about 1 month 3 days. Yeah. Yes, 1 month 3 days.
3 days.
And here
4 months, 12 days. 4
4
months, 12 days.
months 12 days. So then 5 months
15 days.
15 days. Total 5 months total custody. Yes, this exercise you should have done it. Anyway, we have done it. You have already undergone about 5 months, 15 days. Okay. Ask your senior whether you will argue on merits or undergone.
The matter to pass over after.
No, I'm passing now. If undergone, then is because 5 months, 15 days, and see, he's in a position that he's not able to pay 25,000 rupees also.
Right.
90 some below commercial quantity.
13 guilty payment.
13, we will maintain conviction and finish it up. Okay. Pass over, you go and tell me immediately. Ask and yes.
22.
Obliged, my lord.
Yes, sir.
One fee of NDPS Act, my lord. And he has been sentenced to undergo 3 years RI and to pay fine of ₹10,000. The short case of the prosecution is that on 22/3/2007, the SI of Excise
EI and EV Unit 1 cutter, when he was along with his staff performing patrol duty at Mangalabag Square Mile, they got reliable information that the present appellant was in possession of brown sugar in Machua Bazar and standing near the Machua Bazar Chowk. They immediately proceeded there and
You have been apprehended and
and they are apprehended. Here I will not take much time since I have prepared a note, my lord. My first contention is that in this case, section 100, subsection 4 of section 100, subsection 4 of CRPC has not been complied with. They have violated it.
Yes.
Admittedly, Machua Bazar Chowk is a very busy place. There are offices, residential houses, shops,
two independent witnesses.
two
That's right.
independent witnesses, two local inhabitant, respectable person. They have not, and they picked up two passers-by, out of which one is from Jaspur, my lord, and temporarily he was staying at Keutasari, and the other one is a person having 3 robbery cases in his name. They are the independent witnesses.
You say that though the two witnesses are there, but they are not respectable.
My lord, and they are not the locality even. Section 100 for CRPC says, I'm just law postulates that section 100 of CRPC shall be strictly followed before conducting search and seizure. Subsection 4 of section 100 says that the officer or other person about to make the search shall call upon 2 or more independent and respectable inhabitants of the locality in which the place to be sought is situated, or any other locality if no such inhabitant of the said locality is available or is willing to be a witness to the search, to attend and witness the search, and the officer may issue an order in writing to such persons or any of them to be a witness to the search matter. Here they have not even attempted. No evidence to show that someone refused of the locality. They have sought for their assistance. And
What is the PWs?
My lord, PWs, all total 4 persons were examined, my lord. Out of them, one
PW
independent witnesses.
PW3, PW,
One, my lord.
PW1. Both of them, according to you, are not the local inhabitants. So
Right.
therefore, section 100.
And not 2 persons, having 3 robbery cases. They are stock witnesses of the police.
Let's talk with him.
My lord. They have,
Have you cross-examined while cross-examining the IO? Have you put questions?
Yes, ma'am. Yes, ma'am. There we have elicited from their mouth that it is a busy place having residential houses, shops, and all that. And they have not given any explanation in their case. And the learned trial court held that it is a very busy place, and he will not find go from door to door to search independent witness. That is the reason of the learned trial court. And I have cited a decision to that effect, my lord, 2003-24 OCR State of Orissa of our Honorable High Court, my lord.
Which
Where
para?
it has
Which
been-
para? Para 9. 8.
Para 9. Para 9.
Yes.
Para 9.
Yes.
Here the court has gone to the extent of saying that the on section 100 subsection 4 has not been complied with, then it will be presumed that section 50 is also not complied.
This is 50. 50 demands that.
My lord. And this section is not inconsistent with the rules of the NDPS Act. Since no rules to that effect in the NDPS Act, CRPC is applicable.
Yes. Yes.
Then, my lord, section 50.
Let us read the judgment which you para 9. So far as the present case is concerned, search and seizure was made in accordance with the provisions of section 43 of code, and since it is a case of chance detection, therefore the procedure provided under section 41, 42 could not have been followed by PW3, and that is clearly readable from the his evidence. Section 50 was not complied with because it is not a case of different that though you wanted to search the presence of the registered officer magistrate, but the chance was declined by him, and therefore actually there was no breach of section 43 and 50 of so forth. But the provisions of section 100, this one you are saying, but the provisions of section 100 they have been related to the securing attendance of two or more witnesses in locality was completely departed from, and in that respect, the explanation it comes from the resolution different three books from section 7 which are relevant to this also. ठीक है. And is applicable to spotted to which the accused detained such in a crowded place and activities almost for the Bombay. Because it is not even breathe a word. Breathe a word as to why even with interesting persons or locality but not. See, in this case, the case which you are citing, there was no witness at all. So I also have passed a judgment in this regard. If in a crowded place this happens, then section 100 clause 4 and 5 has to be complied with. There are two independent witnesses to be there. In this case which you are citing, in that case there was no witness at all. But in your case, two witnesses are there. What you are trying to say is they are not respectable.
Not respectable or locally elected.
They may be a chance witness also. They may be there in the market. It is market. They may not be local resident. They may be from somewhere else. They may be in the market. How this the witness credibility of those witnesses will be doubted merely because of
Hey, respectable persons means, my lord.
with this
Take
respectability
one
is a very
witness
relative term.
One witness out of them.
Hmm.
Three robbery cases are pending against him.
This
He
is again
admitted his
relative term.
evidence.
Now, let us see the evidence what you have put to them.
My lord.
Let us come to. Yes.
The
PW1.
position of PW3, my lord.
PW3 you want. Let us see the PW1 first.
First,
He has turned hostile.
both of them turned. Yeah, the person is, my home is at Mauja Biraja Police Station, Jaspur. Biraja Sai, Jaspur. And present in Mauja Keuta Sai, Katak. Police Station, Mangalabad.
He has admitted that he has two cases against him. Huh?
And the principle is decided in that decision, my lord, I get to submit your lordship. The principle is decided.
The principle says that you need to have two witnesses. That's the principle. But in your case, witnesses are there. Not that witnesses are not there.
No, it-
Witnesses are there. They supported. They have not supported the prosecution. That is another story. But what you are trying to say is the credibility of that witnesses has to be, seen in view of their involvement in other cases.
That is the.
But we don't have-
The
Yes.
the section 100 and both CRPs, my lord.
This
That is my submission.
yes, yes. Let us see the who is your IO.
IO is PW4.
He has not proceeded. Procedure ତାର କିଛି କରିନାହିଁ।
ନାଇଁ ନାଇଁ ସେ କଥା ନୁହେଁ ଦିଟା କ୍ରସ୍ ଏକ୍ସାମିନେସନ୍ ପେଜ୍ ଇଜ୍ absent, my lord. Man, it is not on record. I have procured the papers from your lordship's office and that page is not there. I have tried it in the lower court also. There also page 9 and 10 of cross examination part is absent. କରିନାହାନ୍ତି କ'ଣ ବହୁତ କଥା ଅଛି
Yes. Page 8 ଅଛି ତାପରେ 11 ଅଛି।
my lord. Cross examination part ର ଦିଟା page ନାହିଁ।
ହଁ। ଏଇ ମାନେ ପାରା ଅଛି 14 ପରେ ଡାଇରେକ୍ଟ 20 ଆସୁଛି ପାରା।
Section my lord, the 100 euro.
I have read it. Don't worry about it. In one case, I have myself acquitted because of non-compliance of 100.
That is one of the grounds. There are other grounds, good grounds are there.
Okay, this ground. Apart from that, what?
Let us
Who is two? Who is two? Two is
Two is the
ASI.
ASI.
Was
Who is the ASI who participated in the search and seizure
Yes.
and entirely assisted the PW4. The
PW4.
PW4 is the everything. He has done everything.
Yes.
Then, my lord, section 50, it is written in page 6 of my written note.
Yes.
It is 50 is applicable in this case since the brown sugar has been recovered from the chest shirt pocket.
Mm.
So it is on question. There is no dispute regarding that. This section 50 is applicable in this. What happened, my lord? Here the PW SI PW2 and PW4 they have stated that they have given a written consent, a written option to the accused that whether he wants to be shot before a gazetted officer or a magistrate.
Mm.
They say they orally denied.
But nothing is
to the
right.
option. No written consent has been procured by them. ନଦେଲେ ଚଳିବ କଥା ହଉଛି since you have given a written option, you should obtain a written consent from them. And that is, I have not cited any decision in this matter. Your lordship must have been.
Yes.
Exhibit 6/1 is the written option. There, even that is in that document also, there is no endorsement that I have gone through it or it is explained to me what is written in it, and he has just given a signature. There is a signature in that document. Where this he has given an endorsement that mu bujhi pai. They could have done in this case also.
Yes.
And it is a mandated provision, my lord. Partial compliance is no compliance.
No complaints. Yes. Let us read 50. 50. Let's see 50. Where have we reproduced 50?
Section 50, conditions under which sorts of persons shall be conducted.
Yes.
When any officer duly authorized under section 42 is about to search any person under the provisions of section 41, section 42 or section 43, he shall, if such person so requires, take such person without unnecessary delay to the nearest gazetted officer of any of the departments mentioned in section 42 or to the nearest magistrate. Subsection 2 says, if such requisition is made, the officer may detain the person until he can bring him before the gazetted officer or the magistrate referred to in subsection 1. Subsection 3, the gazetted officer or the magistrate before whom any such person is brought shall, if he sees no reasonable ground for search, forthwith discharge the person, but authorized shall direct that search be made. Next, subsection 4. No female shall be sought by any one excepting a female. Subsection 5. Subsection 5. When an officer duly authorized under section 42 has reason to believe that it is not possible to take the person to be sought to the nearest gazetted officer or magistrate without the possibility of the person to be sought parting with possession of any narcotic drug or psychotic substance or controlled substance or article or document, he may, instead of taking such person to the nearest gazetted officer or magistrate, produce the search the person as provided under section 100 of the Code of Criminal Procedure.
Yes.
100%.
Yes. The 100 request
Written
to
ଦେଇଛନ୍ତି କିନ୍ତୁ written ଆଣି ନାହାନ୍ତି ସେ
Hmm.
କହୁଛନ୍ତି ଯେ orally କହିଲା
Hmm.
which is not accepted.
yes. Therefore, you say that it is a part compliance.
Part compound.
Yes.
Given in writing, but
Hmm.
then not sought for the option in writing. And he could have even my lord, your lordship may see the exhibit. That is the document they have exhibited.
Hmm.
Your lordship may first see exhibit one by one.
Yes.
Result.
Yes.
In the back side of this result list, ସେ ଲେଖିଛି the accused ଜବତ ତାଲିକାର ଏକକିତା ନକଲ ବୁଝି ପାଇଲି. Then thereafter is signed.
Yes. This is in seizure list.
It is in this back page of the seizure list.
Seizure list. Okay.
Page 64. 65.
Hmm.
And 6/1 is the option letter.
6/1. Let's
6/1.
Hmm. Yes.
He has signed Paramananda Sethi, and the date is given by someone else.
22/8.
And no endorsement to that effect. And I have gone through it, or it is explained to me,
The
and I am unable to write.
but he has signed it.
He has only signed.
Sign it. Then the let us see the PW4 what he says regarding this. PW4. Now to page 2 of PW4.
Mine.
I had earlier I called the local witnesses, detained the accused. I disclosed at the top. I disclosed my identity to him and expressed my intention to search him after the intimation given therefore. I explained him that he had the right to be searched either in presence of the gazetted officer or a magistrate, I sought for his
Option
option in
in
writing. And this is
written
this is this is that written document seeking the option of the accused is 6/1 exhibit written in my handwriting. 6/1 is my signature. The accused received it in my presence by putting his signature, and exhibit 6 is his signature given in my presence.
তারপরও ଅଛି ওরাও consent. The accused did not want to be sought either in presence of a magistrate or a gazetted officer and wanted to be sought by me. He gave his option orally.
Where are we reading?
My lord, paragraph 2, same page now, paragraph.
Last
Uh,
did not want to be searched either in the presence of magistrate or gazetted officer and wanted to be searched by me. He gave his option orally.
my lord. My submission is, my lord, that if they have given a written document, why they have not obtained a written option from him?
Wait, do you have
And there
any
is no explanation to that.
do you
effect.
have any judgment to support that? Once it is once given in writing.
When?
No, usually you support what is the
Decisions,
support the judgment if you have. Once you have given a written option, it is obligatory on the part of the police officer to get a written consent. The option was given, that is exhibited, and he got the oral option from accused. Is it sufficient? Do you have any supporting judgment to that effect?
present it is not good.
That's a vital point. Because he may not be in a.
If they have given any explanation to their effect, PW4, if they, I have given him consent, if they said that.
And
I cannot
313,
write,
in 313, have you said that I have not given the oral? In 313, when it was recorded, have you said that I have not given oral option of search? Let us see 313. Come to 313. Accused statement.
Question number 4.
Mhm.
Question number 4.
Declare that you did not want to be searched in his home soon. Mention.
କେତେ କହିଲେ page ଆଜ୍ଞା?
You have not said question number 4, very specific question. You said ମିଛ କଥା. ସବୁ ମିଛ କଥା. You should have taken a stand that I have not given oral option.
ମିଛ କଥା ତ କହିଲି।
Come to question number 10. Appear from the evidence that the above named witnesses that the people sees all the 3 packets. ସେମାନେ ସାଦା କାଗଜରେ କି ସାଦା କାଗଜରେ ମୋର ଦସ୍ତଖତ ନେଲେ। एक्साइज बाबू मो घर को जाई मो घर वोटर आई कार्ड आनिले सादा कागज रे मो दस्तखत नहीं मित्र को
6. Yes, sir.
6
Right. It also appears from the evidence of the above named witness that on such a person, Figure 4 recovered a small generated from the face pocket of your side, along with cash of 500 MB and your voter ID card. What is the mission?
ये बिक्यो आज्ञा ये बिक्यो तार पॉकेट भीतर ब्राउन सुगर आ
Voter ID card
माने हाईली इम्प्रोबेबल थिंग हाईली इम्प्रोबेबल थिंग
ସେଠି କାଇଁ voter ID card ଲେଖାହେଇଛି voter ID ଟା କହିଲା ମିଛ କଥା last କୁ କହୁଛି ଆଜ୍ଞା ହଁ voter ID card
ମିଛ କଥା କହିଲା ଏ ନାଇଁ ଭୋଟର ଆଇଡେଣ୍ଟି କାର୍ଡ ଆମ ପକେଟରୁ ଜବତ ହେଇନି ଆଉ କଣ କହିଥା
voter ID ତମ ବାହାରରେ କହୁଛି voter ID card ଆଣିଲେ ବୋଲି
ଭୋଟର ଆଇଡି କାର୍ଡ ତା ଘରୁ ଆଣିକି ପୁରେଇ ଦେଇଛି ନା ବୋର୍ଡରେ
Yes, any point, any other point? This
Oh,
point.
I know many points are there. If your lordship will satisfy with this, then I will not go for.
ସେ 1 year 9 months ରହିଲାଣି
ରହିଲାଣି ଆଉ
नहीं है तो ऑलरेडी अंडरगोन कर
already on ଭଲ କେସଟା ମାନେ ନଖାନା ରେଜିଷ୍ଟର
ଭଲ କେस तो
ଭଲ କେସଟା ଅନଲାଇନ କର
अच्छा
your lordship may go through the written argument then pass any order I am
नहीं नहीं बेटी you are insisting for acquittal. Let us see. It may be a case for acquittal. Not that you have made out a point. This point is relevant. Oral option. Can you give me any judgment? Then oral option. Then this point may work in your favor. And apart from that, what else? Only you are insisting on the non-mandatory provisions.
no there is also non-compliance of 52(1),
Wait, provision.
52(3). Thereafter, my lord, they have not followed the provisions of section 55. These things are and that there is many more material contradictions. ସେ କହୁଛନ୍ତି ମାନେ ASI କହୁଛି ଯେ ସେ ଯୋଉ ସିଲଟା ବସିଲା ସିଜ୍ ଆର୍ଟିକଲ୍ସ ଉପରେ and sample ଉପରେ ସ୍ପଟରେ ସେ ସିଲଟାରେ RC ମିଶ୍ର ଲେଖା ହେଇଥିଲା ନିଜେ PW4 କହୁଛି ସେଥିରେ RM ଲେଖା ହେଇଥିଲା ମାଜିଷ୍ଟ୍ରେଟଙ୍କ ପାଖରେ ପ୍ରଡ୍ୟୁସ ହେଲା ବେଳେ ସେ କମ୍ପେୟାର ହେଲାନି ସିଲ୍ ପ୍ରଡ୍ୟୁସ ହେଲାନି these things are there ସିଲଟା ପ୍ରଡ୍ୟୁସ ହେଲାନି
Which point? Which point? That is point number.
ପଢ ଦିଅନ୍ତୁ ତିନିଟା ଦେଖି ଦିଅନ୍ତୁ ଆଗରେ mandatory provisions of section 52(1) and 52(3) of the NDPS Act have not been complied with. ସେ ଏଥିରେ 52(1) ରେ କହୁଛି
Point number 5.
point number 3
5. No, there are material contradictions in respect to the impression of the brass seal, weightment of the material and drawing of samples, sealing of the same, and with regards to the color of the brown sugar. There is a serious material contradictions regarding the impression of the brass seal. This is so also. There are 57 is hit here.
In 57, I am not taken a ground. The custody बिल्कुल होंगे.
Or they will be part of the evidence stated that the impression is initially RM.
Magistrate भी compare करेंगे. भाई सील को अवसर नहीं जो सील देगी. जैसे भी କହୁଛନ୍ତି ଯେ ସେ ଯୋଉ ବଲ୍ କ୍ୱାଣ୍ଟିଟିରୁ ଆଉ ଥରେ ଗୋଟେ ସାମ୍ପଲ ଡ୍ର ହେଲା ପୁଣି ନିଜ କଥାକୁ ନିଜେ କଣ୍ଟ୍ରାଡିକ୍ଟ କରୁଛି ଯେ କିଛି ନୂଆ ସାମ୍ପଲ ଡ୍ର ହେଇନି ଆଉ ସେ ପୁରୁଣା ସାମ୍ପଲକୁ ଭାଙ୍ଗିକି ଗୋଟେ ତାଙ୍କ ସିଲ୍ ଓଜନ କଲେ ଆଉ ସେଇ ସିଲ୍ ଦେଇକି ସେଇଟା ASI କହୁଛି ସବୁ ସିଲ୍ ଭାଙ୍ଗିଦେଲେ ସେ ସିଲ୍ ତ ତାର ଯୋଉ ସିଲ୍ ହେଇଥିଲା ବ୍ରାସ୍ ସିଲ୍ that was not produced matter. Then the IIC again put his seal when the things were kept in the police custody. He has given his seal. That seal also not produced or the IIC, the authorized person, they have not examined in this.
Reseal, PW2 seals, reseal that PW2 seal. Evidence PW2 contradicts in that respect.
କଲରଟା ଟିକେ ଭୁଲ ହେଇଯାଇଛି ସେଟା କେବଳ ଏସ୍ଆଇ କହିଛି PW4 କଲର କଥା କିଛି କହିନି
କହିନି।
I have written that both the official notes. Yeah, that is my mistake.
Then your strongest point is section 100.
No, my lord, section 150 is the strongest point. to
50.
my
Partial compliance.
my-
Partial.
Then 52(1) and 52(3).
Hmm.
These two sections are also very.
Let us see now. Submission number 3.
My-
Exhibit 5 is said to be the memo of arrest claimed to have been prepared in the spot, and a copy of the same was given to the accused. And in the separate document, the quantity of seized brown sugar has been written, and the space for writing.
Although this
Same
document
means
is available on record,
Right.
they have not exhibited it. And the defense has asked him questions regarding that. Suppose
And the exhibit, there is a blank.
two blanks are there,
Hmm.
regarding
Wait.
the payment of the yeah. And if ଯଦି ସେତେବେଳକୁ ତ search and seizure which is over,
Hmm.
memo of arrest ଦେଲା ବେଳକୁ ସେ arrest ହବ। ସେତେବେଳକୁ ବି ଯଦି ଓଜନ ନ ହେଇଥିବ ତାହେଲେ ସେ ଜିନିଷଟା ଲେଖା ଯାଇପାରିବନି। Otherwise it is there in the record manner.
Come to exhibit 5. Come to exhibit 5.
Exhibit 6/1 ବାହାର କରନ୍ତୁ ସେ ତାର କରରେ ସେଟା ଅଛି। Memo of arrest.
The space for writing the same remains blank, and we show that the research procedure and the witness was made not by the spot. Practically ସବୁ ଜାଗା ଥାନାରେ ହୁଏ, you know that. ସବୁ ଉଠେଇକି ନେଇ ଥାନାରେ ବସି ସବୁ ପ୍ରୋସେସ କରିକି ସବୁ କରିଦିଅନ୍ତି।
ସେଟା ଧରା ପଡୁନି।
କୋଉଠି ଧରା ପଡେ? Yeah, I'll tell you, if seriously, if you look at the document, all the cases there will be acquitted. Just see the blank. Why you kept that blank?
That is the one man.
You say seizure and everything is done at the spot, and there is a apparent blank, and you have exhibited that document.
No, they are not exhibited.
No, exhibit 5.
Okay, but leading questions have been asked in cross-examination, he agreed. And the learned trial court said that by he take cognizance of this thing. This is the outside negligence of the case, but he did not find it safe to conclude it in favor of the accused.
You see, these are the very, very glaring thing, you know. Utter negligence.
My lord.
When was the samples and everything was sent to police station? You say 52(3) is not complied.
That's what.
Yes.
The SIPW2, he has stated that we have left the spot at 2:32 p.m.
2:32
p.m.
PM. Yes.
Then PW4 says that
Hmm.
PW4 କହୁଛି 2:30 ରୁ 3ଟା ଭିତରେ ଆମେ ସ୍ପଟ ଛାଡ଼ିଦେଲୁ and we straight went to the court.
Hmm.
But the order sheet of the learned SDGM shows that they have produced the accused and the seized materials at 7:55 p.m. Subject to correction, If your lordship appreciate it 255, then I am looking to say. Or yeah, we
Order sheet is 7
order sheet
PM.
dated my lord. Dated 22/8/2007 ଯୋଉଦିନ produce କଲେ
रसी 22/8/2007 7 PM
7 p.m. 7:55, my lord. I think it looks like 5.
700 55 ଲାଗୁଛି rather 57 ବି ହେଲେ
7. Let us assume that it is 7.
even then
Even that ଏଇ ଯୋଉ 4 ଘଣ୍ଟା 5 ଘଣ୍ଟାର ସମୟ ସେ କୋଉଠି ଥିଲେ, କଣ କରୁଥିଲେ, ଜିନିଷଟା କୋଉଠି ଥିଲା, କାହା ପାଖରେ ଥିଲା, ଏ ତ ତାଙ୍କର କେସ୍ ନୁହଁ ଯେ ସେମାନେ ନେଇକି କୋଉ ତାର
What have you- have you-
they have to treat a coin, they have to deposit it in the local police station, local police station for safe custody. He has not done that.
see the stage away they got
And
to
the
it.
learned trial court here that they must have taken some time to have their lunch. Where from he got it, I don't know. It is not on record. Kind ତା ଭିତରେ tampering ହେଇନଥିବ. That is the mandate of the safeguards given in
That's the
act.
idea for this timeline
Fine.
so that there is no scope of any manipulation or anything. What have you asked regarding this? Have you asked to the IO anything?
It is a documentary evidence, so
But
I
have you
have
asked?
asked the IO. I have asked them.
Let us see whether he has explained.
I have asked or he has stated something like that.
He says that in the para 5, he says that straight away from the spot he went to the court.
Madam. The court is 3 kilometers from my shop. You have to know that. Hardly 6 kilometers from. It will take maximum half an hour. And why he produced it at night, even if it is 7 p.m.
No, para 5 just read. Para 5 of the evidence.
Evidence of PW4. Alert.
I recorded the statement of the witnesses at the spot and also prepared the forwarding report. From the spot, I straightaway proceeded to the court of SDGM Cuttack and produced the accused along with the seized articles. The court remanded the accused to the jail custody since it was a late hour of the court that the seized articles were not received by the Malkhana for the court. I went to Lalbagh police station from the court and requested the Lalbagh to keep the seized packets in his Malkhana. I made a written request of so and so to that effect. This is my written requisition so and so. The current copy of requisition is so and so.
The time explanation କିଛି ଦେଇନା. Court ରଖିଲେ ସେ ଯୋଉ sample ଆଉ and the bulk quantity of brown sugar court ରଖିଲେ 30 grams ର ଜିନିଷ ଅଛି.
But Lalbagh police station, according to them, he as I received these articles from me and Malkhana registered. But Lalbagh,
Admittedly, he has not produced the accused or these articles in any local police station.
no, Lalbagh police station. He says
Lalbagh police ଟା court ରୁ ଫେରିଲା ପରେ. I am
Before that, in between.
I am
What you say is from the spot it should have gone to the police station. Thereafter the court.
ଯଦି ତମେ 3-4 ଘଣ୍ଟା ପରେ ଯାଉଛ court, ତାହେଲେ ତ naturally it is to be treated in a
If you want to go for lunch, you should have kept it in the police station, then have lunch, then
lunch cannot take 4 hours, madam. So 4 hours lunch cannot be taken, and it is not on record. They have not explained that we have taken our lunch during that time. It is out of record.
Yes.
Thereafter, my lord,
Hmm.
in Lalbagh case, he has given a requisition.
So this is about 52-3.
My lord.
And what is 55?
Para 4 से निकली इधर से para 4 pidot 4
Hmm.
I arrested the accused after spending in the grounds of his arrest as he was in illegal possession of the grounds without an authority. The bag still used for seizing the sweet packets was made over to one of the seizure witness, namely Chandra, who acknowledged receipt of it executed in the Juma 4/1. Executive 4/1 is that Juma number written in my handwriting. The 4/4 is my signature on the Juma.
Ticket is made over to one of the seizure witness. Jagannath Lai. That he is PW? Has he been examined?
PW1
Jagala.
Three.
He is not
The
supported.
duty of the prosecution.
Supported, but since you put in the explain is here, what
An explanation that the burden is on the prosecution to prove everything, my lord.
After completion of the surgeon, she is prepared. Okay, 55 also you have given the explanation.
Next point is 55 and
चलो ठीक है. I'll see.
what is the OGT
Yes. Yes.
After completion of search and seizure, the seizure list was prepared at 11:15 AM and the accused was arrested. And the consistent evidence of PW 2 and 4 is that they left the spot at 2:30 PM in an official jeep and straight proceeded to the court of LTJ, and produced the accused along with the seized articles in the court. The distance between Machua Bazar and the court is nearly 3 kilometers. Even by walking, it will take half an hour to 45 minutes to reach the court. But the order sheet of the learned SDM dated 22/2007 shows that the material and the accused were produced at 7:55 PM in the night, nearly 5 hours after they left the spot. There is no evidence, either documentary or oral, to show that during the approximate period of 2:30 PM to 7:55 PM was in custody of the alleged seized articles, and the materials were kept in safe custody till the production in court. In their evidence, PW 2 and 4 are completely silent as to why they produced the accused and the seized materials at 7:55 PM beyond court hours in the night, although they left the spot at 2:30 PM. And the seized materials were kept with whom during this intervening period of 5 hours. Therefore, the prosecution failed to prove the safe custody of the materials during this period. Therefore, the possibility of tampering of alleged contraband cannot be ruled out till production in court. The justification of the learned trial court that excise officials must have taken some time after 2:30 PM to have their lunch, and there is nothing unusual if they produce the accused and materials in the court at 5 PM. The 5 PM da bol
Hmm.
is nothing but
7 PM उठा तो.
maximum 7 PM. But surmise and conjecture of the learned session judge, since there is no evidence on record to that effect. In the present case,
I got it. I got that point. I got that point.
More written argument.
A written argument. I got
Page
it.
10.
I just see that. You said undergone how much period?
1 year 9 months.
এটা খোলা সভা কেসটা
बेल में जमा जाएगी
Huh?
बेल में जमा जाएगी because you was arrested on 9/6 arrested on
Hmm.
custody on 22 March 2007. Judgment is on 9.
Is there any antecedent against? Is involved in any case?
No.
Antecedent.
লালবাগ পুলিশ স্টেশন
Okay. I'll just, thank you very much. Thank you very much. Okay. Now, your phone number. Okay, you will be appointing an office for you. You would assist me on other matters. You have to assist me in other matters also.
Order is yours.
What do you want?
No, no, I'll do one. This is for the service.
May also go through the citation that.
I
think he will be active.
It is well drafted, the written submission, and good judgments are also there. Judgments are there. And anybody is ready for argument, any matter? Who was there? You were there. His lawyer has not come, no?
My lord, sir, I am the opposite party number 2. Can take.
No, but his lawyer was supposed to come.
I'm here to appear as a party person, sir.
You said you will call your lawyer?
No, sir, I actually NOC, the Wakalat Namu. It was with her. So
Acha.
I came with the memo and the Wakalat.
What do you want, sir?
Sir, I wanted to put my all facts in front of you, sir.
Wait. So, na?
Cases were, sir,
1 minute. Yes.
so as soon as her affair with her paranormal got revealed, and she took undue advantage of the law and section 498 and the following sections. As she confessed also in the prosecution witness in the family court.
Sir, what have you moved? Permission is granted.
I moved for the entire criminal prosecution.
Notice to be got to. What is he? Modification of order dated 2/12/2024. 2/12/24. 2/12/24 ରେ କଣ ହେଇଥିଲା? No, what do you want?
Sir, I'm here for the approaching the honorable court for the passing of this matter, sir.
No, notice has been issued.
Yes, sir.
And you are seeking modification of order dated 2/12/2024.
Yes,
In
sir.
the
It was actually-
in that order only notice was issued. What do you want? Modification means I will not issue notice to the other side.
So the notice has been served and the opposite party has been appeared.
No, it will be heard. Why are you asking for modification?
No, sir,
See, what I did is you asked for quashing.
yes, sir.
I issued notice to the opposite side.
Yes.
Okay. And the matter is now has to be heard by the concerned court. You moved an application for modification of that order. How can I modify? If I modify, then I'll have to dismiss it only. This order is in your favor. Why have you asked for modification?
So-
Therefore, the coordinate bench said, since you are seeking for modification, so I have to hear it. What is this order? Just see, the order is, I'll read it for your benefit. You are misguided. Issue notice to the opposite party, Mr. Kumar, Leonard, additional standing counsel, so accept notice. Issue notice to be issued to the opposite party number 2 by the speed post, so. Release the matter on sunset.
Actually, so my past advocate, she was supposed to say that to stay, not the adjourn, sir. Because actually I'm facing too much of.
Acha, you say that I have in the last paragraph I say that
Yes,
you can seek an adjournment there in trial court,
yes, sir.
but you want a complete stay.
Yes, sir.
Complete stay. That is the modification.
Exactly.
No, do one thing. Instead of asking for modification, you move an application for stay. Okay, you move an application for stay, and that application for stay will be heard by the court, the concerned bench. Don't ask for modification. This order is already executed. I said you seek an adjournment. You sought already adjournment. Now you want a stay. Therefore, you have to move an application for stay. Did you follow? You move a separate application seeking stay for the impugn order. Okay, move application. Letter counsel for the petitioner. This is an application seeking modification of order dated 2/12/2024. The matter was listed before the coordinate bench. The coordinate bench is directed to list the matter before this court because by the application, the petitioner is seeking modification of a particular order passed by the bench.
Sir, the I has already been filed, sir,
Stay.
before the stay, sir.
Stay is something different, modification is something different. You have
The I
moved
is already
application for
filed, sir.
modification. Where is that modification after? So you have to, I'll give you that release.
Sir, actually, I'm traveling from Dhanbad to here, sir, and there is a lots of things to harassing me, sir. In the lower courts,
I
the
understand your
professor-
problem, but see, you are technically you are making a mistake, so therefore that is the reason you are unnecessarily wasting time. Why don't you, who is your lawyer?
Sir, Miss Ruchi Rajgaria.
Call her.
Sir, actually, it was just going delayed, sir. Since 2 years, the FIR has been lodged. There is
It's all right now. Call her. I'll make her understand because these are very technical things you may not understand.
Sure, sir.
Did you follow? I'll wait for her. Please call her. I'll here at 12:15.
550, sir.
Call her. Okay. Why have you taken? She has been doing good for you.
No, sir, she is doing good. It is going delayed, sir, and the FIR
Delay is not because of her. Delay because of the system. No lawyer can be blamed for that.
Sir,
See how many cases are pending. You know that.
exactly, sir.
So therefore, don't blame lawyers. Lawyers are doing their best,
Sir,
but
in
the
trial,
system is such. What to do?
sir, in trial court, I am facing professional misconduct, sir.
Okay, you call her. You call her. I'll make her understand. Thereafter, pass the order. Okay, you call her. I'll just come. Yes, Mr.
Item 46.
I'll take.
My friend is
Does not do like all. The judgment copy also not. So I will,
Here.
yes, I will take the code copy.
You take code copy now.
but it's very difficult to read. I have taken every pen, but I thought that's just
That's a code.
319 pits only she has been added.
Whatever, just see. If it's not legible at all, none of us can read it. How can you?
ସେଇଥିରୁ ଟିକେ ଚେଷ୍ଟା କରି କରିଛି
I'll just come at just 10 minutes.
Item number 19. It was late in coming, but we talked about
Yes,
the
yes.
matter.
Pass over. Huh? Okay, okay. You didn't come yet.
I was little late due to rain. I should have been editing, but I'm sorry. Ma'am.
Mr. Das was appointed. Huh? I would matter color Mr. Das. Huh? कह दो. Huh? Since you didn't come, then I request Mr. Das. Mr. Das is here. Mr. Das, the matter in which I have requested you, he is now come. So I will entrust one more matter. Okay. Are you ready now?
No, next week.
98 matter.
Not today.
Day after.
Friday, you also.
No. Day after.
Monday also, Monday also.
Only the Tuesday and Thursday I feel. No?
Tuesday also. Thursday I'll be in
Tuesday.
festival.
Next Tuesday is holiday. We'll let it be there in the list. We'll see. Yes, next come. Yes. 23. Yes, next. 24. Old matter, 94 matter. What is happening in PK Mishra? PK Mishra. Hmm?
23 and 24, the matter relating to SCST Act.
Here, pass it over. Let us see. They may come. Yes. Next. 25. Please come.
Lordship, the paper book is not available, yes.
Madam, how many times I will tell you, paperwork will not be ready. You have to take it, the soft copy you take and argue. These are old matters of 1995.
Your Lordship, I'll collect the TCR today.
Hmm?
I'll collect the TCR today. I just need some time.
This matter is there in the list since last 2-3 occasions.
Your Lordship, I'll positively collect the TCR today.
Now you collect it. Now it collected, get ready. I will not adjourn. Yes, next. 26. 90s matter I will not adjourn.
Your Lordship, just one last adjournment.
Let it be there. You take the copy. We'll see. Yes, 26. 26.
Your Lordship, this is a matter of Section 3 of SC/ST Act. So can it be passed over to the...
Pass over. Okay, pass over. 27. Yes, no reason. 28. 28.
In 27, the appellate has already been released by under PO Act by the court below. Still then they have challenged the appeal.
27.
Yes, 27. The conviction was under 323. Since he was 21 years of age and he was the first time convicted, the learned court, trial court released him on a PO Act.
He is seeking an acquittal, huh?
Yes, sir.
What was the age of this?
21. You should kindly see page 17 of the
90.
paper book.
No. What was his age? 21 years.
He was 21 at the time of occurrence.
So now that was in the year
97.
97. 94. Let us see the charge sheet.
Yes.
28, na? Item?
27.
27. Okay, let us see the 27. Charge sheet, just see the age, you will get it. Charge sheet, no? Paper book is there. Okay. Let us see the charge sheet.
Charge sheet is 22 at the filing of charge sheet.
Charge sheet was filed on
33, 1994.
1994. He was 22.
Right.
Then now must be around 4 days. 22 years दिला
53, 54.
हैं
53, 54.
53 54
He's already been, he's already been released in PO Act.
हाँ but is it a case for acquittal?
Injury report are there. Doctor
Let's
has
see the victim's statement and yes,
PW4 is the victim.
let us see the PW4 victim. 323, huh?
Yes, sir.
Let us,
Conviction is under 320. Conviction is under 323.
let us see what he says.
And he has been acquitted
Name
under
of
section.
the accused is Prabhat Kumar Pradhan. Yes.
Yes.
Prabhat Pradhan.
PW4, Your Lordship. May I please?
Yeah, yes. Read it.
I knew the accused in the dock. The occurrence took place 2.5 years back at about 3 p.m. near Mahishaswani temple. At the time of occurrence, I was returning from Bhagwanpur to my house. While I was returning on the roadside from Mahaswani temple, accused was thrashing black gram on a piece of land close to Mahaswani temple. On seeing me, the accused called bad names, so-and-so, Your Lordship. Why your father had come to our house to challenge us for cutting a tree. When I protested, the accused dealt me 4 to 5 blows by means of a ukhuni badi. I sustained injuries on my back, head, eyebrow. I fell down on the ground and lost my sense. I regained my sense in the hospital.
So what is that?
Pardon?
Khuni
Badi.
body. What is that? Khuni body.
ଉଖୁଣି ବାଡ଼ି ମୁଗ ଯୋଉଥିରେ ବାଡିଆ ହୁଏ ସେଟା ମୁଗ ବାଡିଆ ହୁଏ ସେ ବ୍ଲାକଗ୍ରାମ ସେ ମୁଗ ଆଉ ବିରି ସେ ଅମଳ କରୁଥିଲେ ଏ ଯୋଉ ମୋଟା ବାଡିଟାରେ ଛୋଟ ବାଡିଟାରେ ବାଡାନ୍ତି ସେଇଥିରେ ତାକୁ ବାଡିଆ
अच्छा ठीक है then let us see the doctor.
The doctor is
4 to 5 blows. Yes.
Yes.
Doctor.
Doctor is PW7. Exhibit 2 is the injury report.
Yes.
I'll place PW7 for a minute. PW7.
Yes.
Paragraph number 1. He examined this once on 24th to 1994. There are 3 injuries. One is lacerated injury, 4 into bone death over partial error of the left side. It might have been caused by a hard and blunt open. It was simple in nature. Then injury number 2 is conjunctival ecchymosis of right eye. It might have been caused by a hard blunt weapon. Simple in nature. Third is bruise 2 into 1 inches over right maxillary area near right eye, lower eyelid. It might have been caused by the hard and blunt weapon. It might be simple in nature. PW2 and Exhibit 2 is the injury report. PW2 and 8 are the eyewitnesses.
2 and 8. PW 7 is PW 4 is the
Injured.
PW4 injured. PW 7 doctor.
Exhibit 2 is the injury report. PW2 and 8 are the
Exhibit 2,
eyewitnesses.
Exhibit 2 and PW
2 and 8
2 and 8.
are the eyewitnesses.
Eyewitness.
Yes.
Yes. Let us see 2.
Yes. Sir.
What did you say?
PW2 unit. I know the accused in the dock. The occurrence took place at about 2.5 years back at 3 p.m. near Mahishaswani temple in our village. The accused and his father has a thrashing floor near the Mahishaswani temple. The thrashing floor actually belongs to the deity. While the accused was thrashing black gram, he saw Robby Naik, the son of Ananda Naik. Ananda Naik is the PW1. Seeing him, the accused asked Robby as to why his father had come to his house earlier on the day to challenge them about cutting of some trees. So saying, the accused dealt 5 to 6 blows to Robby Naik by means of a ukhuni. He explains the ukhuni is a lathi fitted with an iron implement which
But
is
he
better
says that
than-
he has given blow to PW1.
Pardon me.
Hmm?
He says Robby Naik, son of Ananda Naik, PW1. PW1 is the Robby Naik. That is a continuation also. He saw Robby Naik, son of Ananda Naik, PW1.
Ananda Naik is the PW1. You see, PW1 is Ananda Naik.
Yes, Lordship.
He is the father of Robby Naik.
Robby Naik. Robby Naik is
Robby Naik is PW4. Huh?
four.
Let us-
Three injured.
Yes, yes. Take it. Okay.
So seeing him, the accused asked Rabi as to vice versa. The accused dealt 5 to 6 blows to Rabi Naik by means of ukhuni. He explains that a ukhuni is a lathi fitted to an iron implement which is bent at the end and used in the thrashing of crops. Robbie sustained injuries on his face, head, face, back. All the injuries were bleeding injuries. I intervened in the matter for which the accused.
It also says the same thing. By means of a
Yes, Your Lordship.
ukuni, he
Yes.
gave 7 to 8 blows. He said 7 to 8.
Huh.
Who is counting the blows?
The injured said 4 to 5 blows, and the corresponding injury report said there are three lacerated injuries, and they said there are 5 to 6 blows or something like that. Initially, the accused was charged under section SC/ST Act as well as 379, 323, and other. That was the conviction is only under 323. Only one ground is there. The occurrence took place on 23/9/1994, whereas the FIR lodged on 30th March 1994.
Delay.
Delay. That is only. And that has been explained. That has been explained by in the FIR itself. May I read it?
Who is R. Mahapatro? You know him.
Since he has been already been released under PU Act, I don't think so. The only ground of appeal, which is an arguable point, is the only delay in lodging of the FIR. Otherwise, PW 4, 2, and 8, and read with PW 7 with the doctor and the injury report. Covered is the
पासवर्ड करो इसको कर देंगे
yes.
और it is done, huh? I'll give the case, no? If he comes, just see R. Mahapatra if he's there, call him, otherwise I'll finish. Yes. 20, 28, 29, 29, 30. Yes, 30.
The Lordship, item 30 is, can you do faster?
Password. 30 password, yes. 30, 31, 32,
May I please, Your Lordship? This is a part heard matter.
100.
Yes, Your Lordship.
Yes.
Your Lordship, I'm providing the note.
Are you ready? That is the offense?
The offense is under 452, Your Lordship, 1 year, 325, 1 year, and 506, 2 months.
Yes. Yes.
Your Lordship, on last occasion, whatever discrepancies I tried to show Your Lordship, I've mentioned that in the note, Your Lordship. There are a few other things I found out. I'll take Your Lordships to that.
Read the submission.
Pardon, Your Lordship.
Submission you are reading.
No, Your Lordship. There are, apart from the submission, other discrepancies are there. I'd like to show that to Your Lordships. Your Lordship, we kindly see page 198 and 99 of the LCR, Your Lordship.
Yes. What do you want to show? Case diary.
Yes, Your Lordship.
What do you want to do?
Your Lordship, in the exhibit, in page 198 towards the last, there is the 161 statement of the casualty medical officer, Your Lordship.
Hmm.
There she has stated that she stated to the casualty medical officer, Your Lordship, that the injury sustained by her was due to falling near a well.
First, tell me I have forgotten. You tell me what is the fact.
The
Let us
fact is,
understand. What is
Lordship,
the prosecution?
it is alleged that PW4, while she was at home with PW5, her daughter,
Hmm.
the appellants entered the house, trespassed the house, and then they have abused her in in a bad language, and then they have assaulted her with the means of an iron rod.
Okay. Who are the eyewitness?
The eyewitness is PW5, Your Lordship.
Only PW5 is the eyewitness. Okay. Medical officer is PW1.
Yes, Your Lordship.
And post occurrence witness is PW2.
The PW2 has completely denied seeing any such occurrence.
Okay. And who is PW6?
PW6 is the son of the informant PW4.
IO is PW3.
Yes, Your Lordship.
Very interesting. IO is examined first. Okay. Yes. Let us see. Let us come to PW4 first. PW4. Reading. 8 years ago, on the evening of also myself and my daughter Sunita. Sunita is PW
5.
5. Sunita were there in our house at evening, what is that? Arabindanagar. At that time, how many appellants are there?
Appellant is one, Your Lordship. Only K. Rajeshwar Rao.
What I have written is the PW4, the incident has taken place on 13/11/1991,
Yes, Your Lordship.
whereas the FIR was registered after 10 days.
Yes, Your Lordship.
Okay. And the doctor examined on the very next day before the FIR was registered.
Yes, Your Lordship.
That is on 14/11/1991. And police requisition is on 23/11/1991.
Yes, Your Lordship.
That's what you pointed out already.
Yes,
I have
Your
noted down.
Your
Let us see.
Lordship, regarding that also, there is another point that it is mandatory for medico-legal cases to be registered on the same date,
Same.
even if it against the will of the complainant.
That's right. That's right.
He has not registered any such complaint, Your Lordship, report.
Because he, the doctor PW1 has examined him on 14th itself. So the FIR should have been done on the same
Yes,
day.
Your Lordship.
That's what you are
He
feeling.
has stated that it is a medico-legal case in the injury report.
Then how many appellants are there?
Only one, Your Lordship, K. Rajeshwar Rao.
What is his name? Rajesh Kumar.
Rajeshwar Rao.
Rajesh Rao. Okay. Let us see the PW4 what he says. When I asked as to ask them as to why they were abusing unnecessarily, accused Badana cut hold of my hair, Shankar cut hold of me from my backside, and the accused Rajshekar dealt severe blow with iron rod.
Yes, Your Lordship.
As the result of which I sustained fracture injury on my hand, and how this is so and so, so and so. After the incident, I was admitted in the medical college hospital, and I was treated there as the indoor patient for 2 months. When I was there in the hospital, the police officers came and I lost the written report before them, and this report was scribed by my son, so and so, then exhibited. Yes. I cannot write to here. Let us see PW.
Regarding delay in lodging FIR, my lord,
Now, let us see PW5. What is the version? Entry in the people, they accuse Rajesh dealt a severe blow. I don't know. Badrinath got hold of. She is also narrating the same incident.
Yes,
Okay. Same thing. Okay. Yes. Yes.
Your Lordship, she has stated before the another medical officer prior to being transferred to this ward, Your Lordship, where the medical examiner examined her. She has stated that I got this injury. Why? Because I fell near a well. There,
Well, which exhibit?
page 199, Your Lordship.
What is that document?
161 statement of Dr. Vijay Sahu, Your Lordship.
Vijay Sahu is not examined.
But Your Lordship, in the 161 statement, he has
But he is not examined. I can't decide the case on the basis of 161. If he is examined, you have confronted with him.
But
I
I'm
don't
just-
know whether it is done or not. Anyway, that besides the point. Next,
I'll just request Your Lordship to kindly
Yes.
praise that fact.
I have seen that Vijay Kumar,
Yes.
Dr. Vijay Kumar Sahu.
He has stated that the fall is possible. The injury is possible
Hmm.
if someone falls on a blunt and hard surface.
Yes. Yes.
Which is why at first they did not treat it as a medico-legal case.
Yes. How have you explained the delay of 10 days?
yes, my lord, Lordship may kindly come to PW4, page 75, my lord.
EW4, huh? Huh.
Yes, ma'am. Is the injured person.
Hmm.
From the first para towards the last.
Hmm.
When I asked as to why they were abusing him unnecessarily, accused by Badrinath got hold of my such and such, and as a result, I sustained fracture on my left hand. Now,
How?
this
This hand
this
has become so
fracture
resulted. And after the
during
incident, I was
after
admitted in the
I was
hospital.
admitted in the hospital, medical college hospital, Berhampur, and I was treated there as an indoor patient for 2 months, madam.
Hmm.
When I was there in the hospital, police officers came and I lodged the written report before them. This report was scribed by my son on my instruction, and after understanding the contents, I put my signature on the report. So FIR was lodged in the
He was hospital.
hospital.
Where is the
In the
bedded tickets and all?
Exhibit 2, Your Lordship.
Exhibit?
Exhibit 3.
Let us see the exhibit 2. Take it out.
Exhibit 3.
Exhibit
That exhibit 3.
3. Let us see bedded ticket. What does it say? Exhibit 3. Ward. 1 minute. Ward.
The bedded ticket is exhibit 1, Your Lordship.
Sorry?
Exhibit 1, Your Lordship.
Exhibit?
1.
1.
What is it? This would be
Page 85. 14/11/91 admitted.
He was admitted to hospital on 14th 11. Rajesh Sahu has signed it,
Yes.
basically.
Yes.
Dr. Rajesh Sahu has signed it. What she says is, Rajesh Sahu says that she fell down. So that is the reason doctor thought that it is not a medical legal case. And it was that's the reason FIR was not registered on the same day, that is on 14th.
Yes, well, but that is why.
Though the 14th he was examined.
Admitted.
And you have prepared a requisition on 23rd, where the patient was already admitted and he was already treated.
But admitted on next day.
Next day, but requisition is prepared on 23rd.
Because
After 10
the
days.
FIR was
Police.
raised on 23rd, that is why.
Therefore, you start manipulating documents. 23rd, you registered the document and then you prepare a requisition and place it on record, despite knowing the fact that the patient was already treated on 14th. Then the requisition was manipulated. What was the requisition? Please check this patient. That was the requisition. By that time, he was already admitted and he was fit by that time.
Yes, by that time he
So
was
that-
already
that-
in the hospital.
That is what she is pointing out. Yes. Yes, madam. Anything?
Your Lordship, those were my strongest points, Your Lordship. She herself has stated in front of other doctors that she fell down near the well.
That you say.
But the appellants are accused.
That appears to be correct because Dr. Rajesh Sahu examined him and he is not referred to the police.
Yes, Your Lordship.
So therefore, the patient might have represented, I fell down. So he thought that it is not a medical legal case. So he is not referred to
Admitted.
police.
Got admitted.
Eventually, after 10 days, FIR was reached. Let us see the IO, what IO says. What is written in Odia, just see there, the ward, the bedded ticket, anesthesia.
Sorry.
Hmm?
Sorry, person room को चालू.
See in Odia, what we.
जो अच्छा person room. चालू.
Yes, anything else?
Your Lordship, in the statement of the IO also, second paragraph, he has stated that on 8/5/92 he has seized the bedhead ticket. Your Lordship, after 6 months of sending the requisition.
Hmm.
After 6 months of sending the requisition, he has
Which part of IO statement?
uh,
Para?
para 2, Your Lordship, fourth line.
Read it.
I seized the bedhead ticket.
IO is PW3, huh?
PW3, Your Lordship.
Hmm.
I seized the bedhead ticket on 8/5/92 and prepared the seizure list.
Yes. 8/5/1992. Yes.
Again, after 6 months, he has gone to seize the bedhead ticket, Your Lordship.
When charge sheet filed?
On 10/9/1993.
But the delay is explained, just see in the cross-examination, he says in the on recall, I examined Saraswati Behra on 24/11/2020, 1991. The occurrence took place on 13/11/1991. The informant explained the delay by saying that she and her husband consulted the other family members and the well-wishers before lodging the report that the accused person threatened to kill her. When she was admitted in the hospital, there was a marriage proposal between the daughter of Saraswati, that is the informant, and Sudeep, so and so, who happened to be the friend of the eldest son of Saraswati, but the marriage could not be materialized. I did not obtain any certificate, so and so, so and so. So that is explained.
But Your Lordship, even if we concede that there has been such a fear in her mind, how come after 10 days she was okay to file it?
She has explained this.
But Your Lordship, the main point is that the medical report, even if it was considered as a medical legal case on the date of the examination, that is 14, the medical examiner did not report it.
That is why she explains
Your Lordship,
that you have given threatening to that kill.
Apart from
Therefore, he consulted, gathered courage, thereafter the FIR was registered.
Although she was in a hospital, after consulting with the family members.
And there is nothing, you have not cross-examined, left it like that.
Your Lordship, even if we take that into consideration, the report by the medical examiner to the police is independent of the fact whether the injured person wants to be the complainant or not. It is mandatory that they report it first.
Who reported?
The medical officer. They did not report it, Your Lordship.
If the medical officer, if the patient says that I fell down or something of that sort, it might not have been done. Subsequently, out of fear, she might have said that I fell down.
But in the bedhead ticket, Your Lordship, it is written MLC, medical legal case.
Where is that?
The bedhead ticket, Your Lordship, Exhibit 1.
Exhibit?
1.
1. Let us see. Where does it say?
On the top, it is written, Your Lordship, MLC.
Where is that? Achha. Yes. Yes. Are you supporting with any judgment?
Yes, Your Lordship.
Maharaja Singh. Which paragraph?
Para 12, Your Lordship.
Yes.
The FIR in a criminal case and particularly in a murder. Thank you. Sorry. The FIR in a criminal case and particularly in a murder case is a vital and valuable piece of evidence for the purpose of appreciating the evidence led at the trial. The object of insisting upon prompt lodging of the FIR is to obtain the earliest information regarding the circumstance in which the crime was committed, including the names of the actual culprits and the parts played by them, the weapons, if any, used, as also the names of the eyewitnesses. Delay in lodging the FIR often results in embellishment, which is a creature of an afterthought. On account of delay, the FIR not only gets bereft of the advantage of spontaneity, danger also creeps in the introduction of a colored version or exaggerated story. With a view to determining whether the FIR was lodged at the time it is alleged to have been recorded, the courts generally look for certain external checks. The check is the receipt of the copy of the FIR called a special report. Your Lordship may come to the last line of that para.
Yes.
The absence of those details is indicative of the fact that the prosecution story was still in an embryo state and has not been given any shape, and the FIR that came to be recorded later on after due deliberation and consultation and was then anti-time to give the color of the promptly lodged FIR. In our opinion, on account of the infirmities and as noticed above, the FIR has lost its value and authenticity, and it appears to us that the same has been anti-time and has not been recorded till the inquest report were over at the spot.
Yes. If this is regarding delay.
Yes, Your Lordship.
But do you have any judgment to say that once it is a medical legal case, if it is not registered and the benefit goes to the accused?
No, Your Lordship. I found out the fact today, Your Lordship. So I
Anything else you want to say? Do you want to say anything?
Delay, I have explained.
What is the period undergone? How much you
12 days, Your Lordship.
Huh?
12 days. Your Lordship, on the PW1 has also admitted that he has reported the matter, but no such report has been on the exhibits.
PW?
1, the doctor.
He said.
Yes, Your
Where
Lordship.
is that?
Paragraph 2.
Para 2. Let us see. I have not mentioned the color and the injury, and since we reported the matter to the police as usual on the same day. Okay.
But there is no such report in the exhibits.
Yes. Yes. Do you want to say anything?
No, regarding delay, I have explained. Regarding delay.
But the doctor says that they have intimated the police.
In the cross.
Police should have registered the FIR. Police not registered the FIR.
Not registered.
Till 10 days. In the bedded ticket also it is written medical legal case. Even then you have not registered the FIR. Waited till the complaint file.
Complaint file FIR. Therefore it was.
That is what her case is. So it is not properly explained that way. Yes. Anything else you want to say?
Your Lordship, I'll provide any judgment if
you can, please.
Yes, Your Lordship.
Yes. one case, your junior was saying that is he has undergone or something. What is that?
51 NDPS valid.
Ah. He's undergone, I'll tell you.
Not
He's
right.
undergone
Right.
total cut 5 months, 15 days. I find out from record.
One valid, it is case of acquittal. If evidence of PW9 is to be seen, I was going through here itself because associate who was assigned, his mother has passed. Yeah. PW9 valid is there.
PW?
9.
I think it's 31.
The investigating officer
Item.
has not complied section 42
Which
and
item?
52A.
21.
21.
Instead of going in detail to the all other evidence, first point manner, she is the person who lost the information and he himself was investigated into the case, which has been deprecated by this honorable court in 2000 year.
Ayo.
Same bio, he cannot investigate into the matter. Second ballot, and he has not complied section 42, 52A. I am drawing my lord's attention to that. My lord, as it is, he has stated that I got the information. I called the executive magistrate. And, we had been to the spot. We seized around 13 kgs and so.
Then it has to be heard then if you are aiming at an acquittal. I just asked whether it's 5 months, 15 days. He is already
Out of 2 years.
Out of 2 years. So I'll
If it can be acquitted, well, I have no objection. Well, it can be undergone, but I have no objection.
Undergone करें तो
Again, তার মধ্যে থাকো কিন্তু সবগুলো একটু
How undergone.
undergone कर रहा है. Undergone.
My lord, see item 16.
What a minute. I would
क्या आशी ना तेरा? Date नहीं. Reader आशी. छोटो मेट्रो कहीं भी करूँ आधे घंटे चेक हुई.
Another case, but item number 30.
13.
30. I think well, a report has not been called for. I may be wrong, but
Zero.
somebody day before yesterday gave me a call and said, he is not there. He is no more. Madhusudan Naik. It is not that.
Mr. Dal, Council
I think
submits that he has gone
Item 30.
oral instruction that the appellant, sole appellant is no more. In view of the same, the State Council is directed to obtain appropriate.
Similarly, is ballot.
But the corona time, many people have died.
Ballots.
Irrespective of his.
Similarly, ballot item number 26 also, no report has been called.
26 or report movie. 26. We'll ask for report after 1 year, 1 week.
Ballot.
11th.
11th.
Okay.
Report. 26th. Didang report. Verify. With much difficulty, I could contact the local lawyer, Mr. Nanda from Balagir. He somehow contacted some person. Day before yesterday, he gave me a ring at 11. Sir, Madhusudan Naik is no more. And phone was disconnected. I tried to confirm it. I said, let it
be confirmed on record, let it come. I have recorded. Okay.
1,000 rupees is time.
33. 2 o'clock we'll do it.
Okay.
No, the problem is you undergone and all these things are all right. If somebody is government employee, somebody, then the conviction is problem. So that is the whole difficulty. Otherwise, okay.
I will be part to make a mention. Item 25, my lord, had kept it after lunch. However, my lord, CRA, on the list, it's CRA 319 of 1995. The informant in that case, they have, the informant is dead, my lord. The legal heirs, they do not want to press this case any longer. There's a connected matter that is CRA 323 of 1995.
No, this is a complaint case.
My lord, no, the
Case and counter case.
case and counter case.
There's a group clash.
Huh?
In the first FIR, these are the accused persons who are convicted. In the other case, there are 45 or 50 people who are convicted. That is the CRA number 323 of 1995. That is what she said.
My lord,
What are the offenses?
They have been convicted 326 and 323.
I think in voluntarily causing hurt, my lord. Thank you once. My lord, my submission is that
307, 336, read with 149.
the informant in 319 of 1995 is no longer, my lord, no longer there. The legal heirs of the same, they do not want to press this case.
Kindly see the note.
There is a compromise. The talks of
Compromise.
compromise are going on.
Note, let us see the note.
Kindly see the note.
Appeal
item
stands
25.
submitted against so-and-so.
25. The appeal stands submitted against appellant number 1, 2, 3, 8, 9, 13, 18, 21, and 23. There are 25 appellants. The remaining.
But which one is the connected matter you said?
CRA 323 of 95.
323.
Yes.
That is
So let both the matter be heard.
Tag together.
Madam,
together.
List this appeal along with CRA
CRA 323 of 1995.
323 of 1999.
Five.
95. Huh? Please see. We'll see both the matter. Let both.
My lord, may we keep a longer date, my lord. We are yet to get instructions from the legal heirs. They have to
Let it be on 11th.
of November, my lord.
11th, you try. If it doesn't happen, then we'll see.
Okay.
11th. Okay.
Wait for me.
33. Yes.
This is on the rupees 1,000. In default one.
Yes.
And default fine rupees 1,000. It is sufficient to meet the NC justice. In default, one simple imprisonment for 30 days.
Only 506. And guilty.
This is by Hon'Ble and just him holding the Hon'Ble and DW5 who is the son of the informant went to her mother.
Who is the counsel? Who is that? Non-APS. Non-APS. Satyavadi Mohanty, Abhay Kumar Sharma. Do you know?
I know.
If you can call, she's not interested, then I'll put somebody's names and I'll finish it up. Because see, the problem is Problem is not 1000. Problem is if I upheld the judgment, I have to write a judgment. It is an appeal. If you will say that no, I will confine to the sentence, then that's a different story. But somebody has to tell that. If I'll have to dismiss the appeal, then also I have to write a judgment. The entire thing has to be dealt with. This is.
Let it come next week. I will talk to
That is, please call her. Otherwise, I'll have non-appeals for the appellant. In the interest of justice, please. Day after. Day after. Huh? Day after. Day after. Yeah, he is waiting for. You are waiting for which matter? 42. What is the offense? 324.
I know you 300 ଟଙ୍କା 500 ଟଙ୍କା
Only.
କେସ୍ କାଉଣ୍ଟର କେସ୍ ଅଛି କାଉଣ୍ଟର କେସ୍ରେ ମଧ୍ୟ 323 300 ଟଙ୍କା ଫାଇନ୍ ହେଇଛି ତେଣୁ ଆଉ ଏଥିରେ ମୋ କେସ୍ରେ ଫୁଲ୍ ଅଫ୍ କଣ୍ଟ୍ରାଡିକ୍ସନ୍ସ
No, but acquittal, if you are aiming, then let us see. You have deposited that amount.
No, I have not deposited. I have filed the appeal. Along with 3110 was there, so additional person judges found the convicted guilty.
$323 and $324, no?
324.
Only 324 in respect of appellant number 3, your lordship. There are 6 appellants. So for appellant number 3 is concerned,
6 appellants.
convicted under 324.
No, and fine or fine. Yes.
That part, your lordship.
Only fine.
324. Sentence is wrong then. 324.
320 ଜଣକୁ ହେଇଛି ଏପ୍ରିଲ 3 323 ସମସ୍ତଙ୍କୁ 6 ଜଣକୁ
323.
323 ସମସ୍ତଙ୍କୁ 6 ଜଣକୁ ହେଇଛି 324 କେବଳ ଜଣକୁ ଏପ୍ରିଲ 3 କୁ ହେଇଛି
Or fine.
There is this.
Or fine. Either of these two. Or fine. So what do you want?
acquittal.
I'll give you the probation or dismiss what? I'll give probation. Probation. देखो जी. Who is the file कर दो. 42. Madam, a sixth appellant have filed the present appeal.
No.
All 6 are alive or some
Alive.
Huh?
Report has come alive.
Presently file the present appeal assailing the order dated so order judgment is not so whereby the High Court the accused persons except
Khira Sindhu ji
Khira
होती
Singh
appellant number
Sindhu
3.
are found not guilty of 324 acquitted. Whereby the appellant number 3 appellant number 3 Khira Sindhu Pradhan
Khirasindhu Pradhan
Khira Sindhu Pradhan has been convicted for offense under section 324 IPC and rest of the accused persons are found guilty of offence under section 323 IPC. In lieu of the aforementioned in lieu of aforementioned conviction, appellant number 3 was sentenced to
500 टंका in default 10 days, your lordship.
appellant number 3 has been fined to pay fine of rupees 500 and default to undergo 10 days imprisonment. And so far as the other accused persons are concerned, they have been fined for rupees 300 and default to undergo 7 days. All right. 7 days. All right. The initial next one, the prosecution story is so also. Initially, the accused persons were stood charged for offence under section 147, 148, 324, 323, 294, oblique 149 IPC, reading section 31X for CST prevention agreement. So, the prosecution examined so witnesses,
7 witnesses,
examined
8 witnesses,
for a poorer
8 witnesses.
After analyzing the evidence brought from the court, by relying upon the evidence of PW 2, 3, 4, and 7, 4, 5, and 7, the trial court arrived at the following conclusion: para 11 and 12. No. Para 13. Para 13 is 13 and 14. 13 and 14. On the basis of the aforementioned finding, the appreciation of evidence adduced by the prosecution, the trial court convicted the appellants in the manner as mentioned in the first paragraph of the present judgment. Presently, this appeal is pending since 2007. 2007. At the time of the offence, the petitioner number 1, accused petitioner number 1 was 46 years, whereas petitioner number 41, appellant number 3, 48, 4, 45, 5, 51, and 6, 31. The appeal is pending since last more than 70 years. By now, all the appellants have become significantly finished. At this stage, we are counsel for the
undergone college undergone college because 3, 1, 10 ଅଛି ନିଶ୍ଚିତ ଭାବରେ ଥିବେ କେତେ ଦିନ ଭିତରେ
sorry
3, 1, 10 ଅଛି ମାଜିଷ୍ଟ୍ରେଟ କେବେ ବେଲ୍ ଦେଇ ନଥିବେ ସେ ଭିତରେ ଥିବେ
counsel for the petition. Have you seen what is the undergone period?
No, I have not seen.
Let us check if they are arrested. Just check. Let's see if we can get it. When these people were arrested, file form, just see. Forward when it
19/1/2002
Date of arrest 19/1/2000 19/1/2000 these are 2
2002 arrest হয়েছে,
एक मिनट समस्त 19 तो 19 तो
13 বা 14
19 तो all of them are arrested on 19 ko let us see bail when they got 19 ko yeah. Just see the bail bond. Just see. Bonds.
ସେ 2002 ରେ
23
2002 ରେ arrest
January 23 ରେ ମିଳିଗଲା
22/1/2002 ରେ ସେମାନେ bail bond ଦେଇଛନ୍
3 days
22/1 ଆଜ୍ଞା
4 days
2 days ର
4 days ର ରଖୁଛୁ ସେଇଟା and counsel for the petitioner applicants further submits that all the accused persons were arrested on 19/1/2003 and they were released on bail on 23/1/2003. Therefore, the applicants have undergone about 5 days custody period. And the trial court has not sentenced the appellants to undergo custody, rather impose fine of rupees 500 and 300 respectively, and default sentencing. The default sentence for 10 days and 7 days has been awarded. In view of the same, issue of particular PO sentence modified or already undergone. I'll do it. Why unnecessary? Already undergone. I'll do it. 5 days they've already undergone. Yes. Or fine is there. Already undergone. Already undergone. Yes.
In this case, appellant 1 and 2 expire.
Which better?
13
1 and 2
expire.
only 3 remain. 3 survives, huh? Do you have any? The counsel for the appellant submits that he has got oral instruction. That appellant, 1 minute. Appellant number 1 and 2 has already expired. One and two पे अच्छा insofar as the appellant number 3 is concerned, he is alive. It is there already. Order is there already. Now you have to argue insofar as appellant number 3 is concerned.
Yes,
Argue. Are you ready?
Soft copy.
You take it soft copy. No order is required. You can take the soft copy. Yes. Yes, Mr. Das, you are waiting since morning working. 40. Yes. Mr. Das is waiting.
I have prepared a short note.
Yes.
May it please your lordship. My lord, this is a matter, initial registration of the FIR, so far the offence of 506, 294 and 3110 of the SC/ST Act. My lord, the charge sheet was filed and there is an acquittal order so far 506 is concerned. Now this appeal is confined to 294 and 3110 of the SC/ST Act. So far 294 is, my lord, 1 month is the conviction, 1 month is the conviction sentence, and so far 3110 is 6 months, and sentences are directed to run concurrently. My lord, this appellant is the secretary of Onakadoli Gram Panchayat in the district of Koraput, and the victim PW1 is the informant. She is the sarpanch. PW2 total, my lord, 7 witnesses have been examined. PW2 is the ward member under her, because he is the sarpanch. PW3 is the naib sarpanch. PW6 is the peon. They 4 are connected with the Gram Panchayat. And my lord, other 3 are DSP, IU, other things, official witnesses. So lordship may kindly say, the allegation is that when the sarpanch was returning, my lord, in some obscene language, abused her in some obscene filthy language. My lord, the FIR contents relating to uttering of the word and a charge, evidence, what is confronted under section 313, all are varying. Stage to stage, it developed and exaggerated. Your lordship may kindly see, may I give the note or lastly I will give it. I have prepared the note.
Give it.
The appellant has been held guilty and convicted. A learned session judge comes to also Koraput at Jaipur in criminal trial number 193, arising out of GR case number so and so for offence under section 293 IPC 3110 of Scheduled Castes and Scheduled Tribes, thereby sentenced to simple imprisonment for 1 month and 6 months respectively. Sentences are to run concurrently, subject to set up as per section 428 CRPC. On the basis of the FIR lodged by one Sanjukta Maji Sarpanch, Onakadeli Gram Panchayat, dated 2/8/2002, Machkund PS case number so and so was registered against appellant accused under section 294/506, read with 3110 of SC and ST Act. The appellant was working as secretary of the GP. During investigation, YC Machkund visited the spot, examined witnesses PW1 to PW7, and seized some documents, forwarded the accused to court, and after completion of investigation submitted charge sheet against the appellant accused for the offences are described above. Plea of appellant accused before trial court was completely denied, and false accusation and C in support of his plea, 2 witnesses, defense witness D1 and DW1 and DW2, whereas prosecution examined 7 witnesses. After completion of trial and in trial court on consideration of material evidence and records, and rival contention of the parties, though acquitted appellant accused of offence under section 506, but found him guilty under section 294 IPC read with 3110 and sentenced him as stated above. Being agreed, my lord, this is filed. My lord, the grounds I have stated that section 294 IPC in the present case, in order to make out a case under section 294 IPC, following ingredients are required to be proved by prosecution.
Hey, but first of all, you tell me,
Yes.
the utterances appears to be, you said that the Desiani.
Yes, different.
No, different is different thing.
Yes.
Desia is not a caste.
Yes. Desia
Is not a caste.
the caste has not been referred either.
Then where is the question of SC/ST prevention?
Yes. Community or caste has not been, Godba caste. It is not referred.
See, if you say Desia is a community, it is not a caste. Desia, Adivasi, Desia, when it is said, Adivasi is also a community. So unless you say this caste, that caste, if you don't utter the name of the caste, then no offense under section. Any
Here,
provisions of
Godova has not been referred. Godova is the evidence that rightly.
that's I have seen it now. I have seen the evidence also. What do you say?
The PW one, the informant.
What does he say? You say, see, I'm only concentrating and
313 has clearly stated that I belongs to
I'm not on that. I'm only concentrating on the offense
3.
section 3.
Yes,
eh?
sir.
Of OE.
SC Act.
Come to PW1.
Yes, sir. The digital is 34 euros. I am
Para 2.
Lordship.
Hmm.
While I was returning from Panchayat office, this accused abused me in absence words so and so.
No, so and so, no, the in between.
Yes, yes. This
Deshiani.
ये कौन सरपंच ହେଇଛୁ ତୁ under ରେ ମୁଁ ରହିବି କି?
Then what is Deshiani? This is
Deshiani.
offensive language according to you. Okay? Now come to the other witness.
That corroborated by the other witnesses, Lordship, PW2, Your Lordship.
I don't think whether you understood what I'm saying.
Yes, Your Lordship. They say
Everything is correct. I'm admitting it to be correct.
Lordship.
But merely saying that you are Adivasi or Deshiani, can the offense under section 3 attracts? Deshiani or Adivasi is not a caste at all.
Lordship.
Then the entire thing goes. And again, just see para 6.
Lordship.
Para 6 of the cross examination.
I was examined by
Yes.
police.
Again, she says.
Yes, it is a figure I have stated.
Adivasi.
Lordship. That is Lordship.
Here, in the examination in chief, she says Deshiani, and now she says Adivasi. In both the things are admitted. Even then, no offense.
Para 6.
You show me schedule.
A schedule, Lordship.
Under the schedule, it should be a caste. Show me the schedule, Adivasi or a caste. Show me the schedule. Again, Adivasi. आदिवासी आदिवासी तो क्या हो गया आदिवासी ब्राह्मण के नाम से भी आदिवासी show me the schedule if you can. Adivasi is a caste.
There is a caste also.
This offense goes then what remains?
294 is concerned, Lordship.
The 294 remains.
Yes.
We'll see. 294 we'll see. First, get over this. Show me the schedule.
Lordship.
Prosecution is to establish.
And that is there, Lordship.
Show me. Where is the Constitution of India? Where is the Constitution? Schedule you here and there. See the Constitution of India.
Lordship.
In the Constitution of India, you will get the schedule. Show me Constitution of India. Let him search, you tell me, next 294, 294, yes. You search and tell me the
Yes,
schedule.
sir.
294, yes.
294. And I have to proceed.
Yes.
Section 294 IPC.
Hmm.
In the present case, in order to make out a case under section 294 IPC, following ingredients are required to be proved by prosecution. That offender has uttered any obscene word in any public place. Public place has not been proved and has so caused annoyance to the informant and others. Statute said that it is others, though other persons who are there, they have not been examined. Word obscene is not defined in the court. The term in ordinary sense applies to words that shock the public ideas of purity and modesty. The definition of obscenity differs from culture to culture, between communities and also between individuals within these communities. The term in legal sense used to describe expression that offend the sexual morality. In the FIR dated so-and-so, informant has alleged that on 29/7/2002, accused scolded her by using word Randy Desiani in public place. Appellant accused denied said allegation and examined DW1, DW2 to establish that no such incident has happened. Prosecution has examined informant as PW1. Her statement before court shows in exaggeration of her previous statement in FIR. PW2 is a ward member accompanying informant confirmed to the alleged occurrence stated that appellant accused used abusive word. Other things have been stated.
Yes.
Which also differs from informant statement in FIR and in court. She further stated that no other occurrence took place, who did not support to the prosecution. PW4 is DSP of Masmund and IO in the case. During investigation, he only re-examined the witness who were examined before by OIC Masmund. PW5 is DSP headquarters Koraput who took charge from PW4 and examined appellant, accused and filed charge sheet. PW6 is a Panchayat peon working under the control of an informant. His statement discrepant to PW2 and exaggerated. PW7 is the OIC Masmund PS who arrested the FIR and transported the case to PW4. Investigation of prosecution is perfunctory. No spot map prepared to establish that the incident occurred at a public place. No statement of witnesses before police is proved before court to discover contradictions in the statement of prosecution witnesses for which appellant accused is highly prejudiced. Though it is alleged that the incident happened at a marketplace, no independent local people have been examined in court so as to honor the truth. Moreover, on evaluation of entire depositions, it is revealed that PW1 informant, PW2 ward member, and PW6 peon have supported to the allegation of the informant. All these witnesses have exaggerated to the statement of accusations and other circumstances made in FIR. So, learned trial court should not have relied upon said evidence.
Then essentially what you are trying to say is it is not in the public place.
Not in public.
That is essentially you are saying.
Public and public are present and
But there are eyewitnesses,
Yes,
2-3 eyewitnesses are there.
And my lord, the executive engineer and junior engineer and other persons have been named in the PW3 statement. They have not been examined to ascertain the fact that it is public.
But there are 3. How will
And
you get
the
over
FIR
this? See, how will you get over the PW1, 2 and all?
That I am submitting before your lordship. Your lordship knows by a repetition I am saying. My lord, in the accused statement, the evidence is supposed to be confronted. Your lordship knows, suppose court below has placed reliance on the evidence of PW1, 2, 3. It is usually asked that PW1.
All the incriminating
Your lordship may
evidence.
kindly see, nothing has been asked.
Let us see.
Your lordship may kindly see accused statement. It is to be asked in specific manner. And see page 28. Page 28. It transpires from evidence that, this much, not referring to any witness. It transpires from evidence that on 29/7/2002, at about 7 p.m. at night at Anaka, Delhi, when Sanjukta Maji, the then Sarpanch, was returning from her office, you abused her in obscene words as so and so. This is the only thing. PW1 is supposed to be asked specifically, then PW2 is to see PW1 has said what you have got to say. See, PW2 has said this.
So question number 3, just see.
Question number 3. There were other public present near the spot at that time, namely Jamuna Jalam, Mangulu Patra, and Jagannath Jalam. You were not willing to work under her because she being a lower caste person. So you abused her in aforesaid manner, aspersing on her caste, micha kotha. That I have given evidence. Your lordship knows prosecution, your lordship knows. Prosecution is required to prove the case.
No, what we are testing is abuses are made, no problem. But it is in the public place or not, that is what we are examining. And you say that it was not put to the accused. It is indeed put to the accused.
No,
In
it
public
is
place
not.
you have abused.
You kindly say, these persons have not been examined. These persons have not been examined. The reliance has been placed on the evidence of PW 1, 2, 3. Which evidence this is apparent, my lord, that is nothing asked. PW1, by making reference to PW1, by making reference to PW2, by
Those things are not there. You are right.
And one for your lordships. To highlight this point with permission of the honorable court, your lordship may kindly see two decisions of this honorable court, my lord, exactly on the point.
Do you have the photocopy or something?
I have got photocopy. To some extent, it is not eligible. I will be permission of the court. I will be just placing this book. Then I will be supplementing. I am having. I am having. It would cause some inconvenience to the my lordship. Paragraph 10, your lordship may kindly see. No conviction would sustain if it is not put in specific manner. It is to be couched properly.
It says that all the incriminating evidence which has come has to be put to the accused. If it is not put, it can't be used against him.
And division bench decision, one more decision. I got 5 to 6, my lord. Out of that, my lord, for your lordship's convenience, one decision.
And one of my judgment also I have said that. On that basis I have acquitted.
Paragraph 11, 12, and 13. Relying on
Same principle. Same principle.
Same principle. It has got amplified. It has got amplified. Nothing has been asked. This evidence in what way it would relate, either to the PW1 or PW2. It has to be couched in a proper manner so that I will be in a position to reply to the same. Otherwise, the doctrine of audio altering parting your lordship knows, so that is referred in this decision. Violation of natural justice also telltale in criminal law, your lordship knows by a repetition I am saying.
Principle of natural justice. Audio altering. Yes. Yes.
This is the gyroscopic man.
Please give me gyroscopy.
It may not be to some extent.
It's all right.
That's why I gave the hard copy.
Okay. Yes, sir.
Here is the case, the PW1, the injured and informant, and there is an eyewitness that is PW2, and the 6 has clearly supported the case of the informant PW1.
The question which I asked, you answer it.
294, whether the public place or not.
No. First of all, whether
But in constitution,
Adivasi is a scheduled caste or scheduled tribe?
scheduled tribal also.
How, where from you got it?
That is the exhibit 2 is the caste certificate which is exhibited by
What, show me exhibit.
kindly glance exhibit 2 also.
Show me exhibit. Exhibit
2 also.
Exhibit 2.
That is digital page also. Digital page also 74 also.
Yes, I got it.
This is the certificate that
What is written? What is written? Caste?
no. That is a belongs to Gondaba and belongs to scheduled tribe.
What is the caste written here?
Gadba.
Godba.
Gadba.
Has he said you are Godba? Then?
Mentioned, they say has been mentioned.
Then, unless you take the name of the caste and scroll, nothing will happen. Section 3 will not be attracted. Adivasi, Deshiani and all these things are not caste.
Sir,
You have to use the name of Gadwa and then this poll, then only the offense attracts.
But in rustic village or lordship, in rustic
There is-
village or lordship,
Rustic village or caustic village, I don't know.
I'm not sure.
Evidence, show me the evidence.
No doubt here is the.
How will you sustain the conviction under 3X?
Use this, use. by
What
taking-
what has he used? He said Adivasi. He only say Adivasi.
Aspiring and by using slang language, aspiring the caste. Your lordship,
What
in
is the
public
caste?
place.
What is your caste? Gonda. Gonda is the caste. He has not ordered Gonda or anything. Very good.
But so far 294 is concerned is clearly made out of the public place by using the options some sort of by the that's corrupted by the PDL 1, corrupted by the
294 you have a case.
But so also 3
294 forget about that. 294 you have. 294 then again this problem is the judgment. Public place you have not put anything to see what PW1 has said, you have not put it to the accused. What PW2 has said, that is also you have not put. 3 witnesses you have. Whatever they have said in the public place, this has happened, that happened. Nothing is put. One question only. So he is directly covered by these 2 judgments. What to do? Just see 313.
Yes.
Then 294 also goes. Judgment.
Six months. 6 months.
That is exhibit 2, na?
Caste certificate, lordship.
Exhibit caste certificate. Gadwa. Gadwa is the yes.
Pardon, my lord. Pardon, my lord.
No, see that man, that's item pass out. Oh, 16.
Pardon, my lord. Item number 39.
13.
39.
No, item there is a passover 16. Call 16.
Item 16.
16 passover.
Your lordship.
Madam, what had happened? I tell you. You filed for quashing.
Yes, your lordship.
I have issued notice And instead of giving stay, I have said that you seek an adjournment in the trial court.
Yes, your lordship.
You had sought adjournment and all. No.
Yes, your lordship.
Thereafter, you move an application for modification of that order. Therefore, it went to the other court. Obviously, in the assignment, it will go to the other court. Since you asked for modification,
Again, it
again
came
it
here.
came to modification. If you want a complete stay, you have to move an application for stay.
There's Honorable Justice is saying that already an order has been passed, so you should file a modification. That is my difficulty because my client is a victim of professional misconduct. The same counsel is representing the opposite party. That is the difficulty. He is not submitting any petition for adjournment. That is my difficulty. Unless and until the stay may be granted by this honorable court.
No. Have you moved application for stay?
Yes, IA is pending.
Where is that?
Yes, my lords.
29? This is the stay application. Then I'll modify that order to the extent that you go and press for that application. Because this is not my assignment.
Stay may kindly be granted till the pendency of this case, your lordship.
This is not in my assignment. But for your modification application, it has come.
It has come. I know.
So it will be kind of, changing, bench changing.
No, just because earlier interim application was disposed of by this honorable court. That's why the modification of order has been filed in the.
Where is the order that it says that I will not pass the order on the application? For
Statements,
that there is no order in that application.
No, there is a. Actually, he has taken the file. He has lost faith that I am not working properly. That's why I could not get a stay.
That's what I was telling him. It is not the lawyer's problem, it is the system's problem.
He had flagged.
I know.
Petition for this stay.
See, but he is seeking the modification of the order dated 2/12/2024.
Yes, sir.
In that order only I have issued notice. And I've said that you move application before trial court seeking
The
adjournment.
modification is required to the extent that there may be an interim stay till the disposal of this main case.
Say I have to hear the matter, it's not my assignment.
Worship, in that paragraph 5, you have written that
Yes.
in the meanwhile, the learned counsel for the petitioner may move the application before the learned court below, seeking adjournment owing to the fact that the matter is submitted before this court.
Yes.
If such application is moved, the same shall be considered on its own merit.
That's right.
Its
So
own
that
merit.
own merit,
That is the difficulty. That creates the difficulty.
might be the.
If
Have
that
you-
portion is omitted,
Have you moved any application subsequent to this order before trial court?
Yes, the counsel is not presenting any petition on behalf of my client. That is the difficulty.
No, you are counsel. You change the counsel.
Several times he has changed. The case is pending in Raulkela, and several
Can I
times
do
the
this
same
for
problem.
What can I do? Your own counsel is not moving application. Therefore, I have to change my order.
No, my lords, that is my difficulty because he is the victim of professional misconduct. For that effect, he has already.
Your counsel is.
My client is a victim.
Why?
Because the counsel who was representing him, now he is representing the opposite party. And I have submitted all the documents, certified copies I have
But that
submitted.
can't be a reason for
My lords, because several times he has changed. He is a person of Jharkhand. He is such a far away place, and he is already only earning rupees 15,000 a month. So it is very difficult on his part to reach Raulkela on each and every
What
day.
have you challenged by?
For the sake of substantial justice,
What have you challenged?
cognizance order.
Cognizance order. On merit, you may not be having any.
498 is 323, 506. Because there is nothing, because the wife was pregnant before marriage. When this fact got revealed, she filed these cases. She immediately left the matrimonial house within 25 days. And she has all the original documents, the medical documents and all. But I have filed all the photocopies and these certified copies from the Raulkela court also, the misconduct part. So at least
I need
this,
to move application under 205.
the misconduct, this cannot be the forum.
Those things I am not going to. Why don't you move application
Your
3020?
Lordship, nothing is in my hands because this case is not pending here. This case is in Raulkela and he is.
That is not the concern of the court.
For
Then I'll
sake
modify,
substantial
I'll modify
justice.
the para 5 and say that you will go to
First.
application 205. Because he is resident of.
No, its own merit, my learned friend rightly said that its own merit, if it is deleted, only this part may be deleted, then that will be, it will.
Then he'll
be
never
a
come.
big relief.
He'll never come. Then
That would be the case when they have filed an application that has been rejected.
then I can understand. There is no application. There is nothing. You move application if it is rejected, saying that on merit I am rejecting. Then I can presume that yes, on merit this is creating problem. You have not at all moved the application.
The person is in person. He is in present before this honorable court,
He is trying to make it more critical. Than what can I do? Move application first. Then I'll keep it pending. When is the matter now before trial court? 10th December. I'll just record that he will move.
The learned counsel every
application-
time ask him to
an
come
application
visit
seeking-
Raulkela.
This is an application seeking modification of order dated 2/12/2020. By the said order, this court had only issued notice to the opposite party number 2 and directed the petitioner to move appropriate application before the trial court, seeking adjournment in the meantime, as the matter is sub judice before this court, submission before this court. Learned counsel, Mr. Rajgiri and learned counsel for the petitioner submits that the petitioner has not yet moved any such application seeking for adjournment. The next date of hearing before the trial court is on 10th of December.
10th of
10th
December.
of December. She further submit that the petitioner would move application in terms of the order dated 2/12/2024. If such application is moved, same shall be considered. I have modified this. Yes.
Its own merit hata din.
With this modification, the application is disposed of. The CRLMC 4197 of 2024 released before the assigned bench. Yes.
Much obliged.
Yes. Yes, madam. 2 o'clock.
879.
My lord, I have addressed oral argument
Hmm.
and also filed a written note of argument. I will take another half an hour. Some points were raised by the honorable court. I will explain.
I think your clients are every time your clients are coming and sitting in court. Advise them not to come.
I will advise.
Not to come. This, from morning the senior people are sitting in the court. That is unnecessary. Doesn't look nice. Advise them. What I'll do is Friday I'm sitting after lunch. Friday I'll fix and hear you and ask these people not to come. Advise them why old people are coming on.
Actually, I am sorry, little bit of delay on my appearance. I could have appeared.
No problem. But
I will ask them.
Because the old people are sitting in the court, it doesn't look nice. And Friday I'll fix it because Friday after lunch I'm holding the court.
Half an hour I will take. Not
half an hour. Friday evening. No, Friday. We will hear it's 2 o'clock. May not be that reference. If at all reference, 355. That is, I have asked. Therefore, I'm not sitting in the Friday after lunch. I'm not sitting in the division bench. So therefore,
if possible, before lunch I will.
No. Before lunch I'll be in the division bench. After lunch I'm not sitting. I'm sitting singly.
After lunch.
Therefore, that is the reason I'm saying.
At 2 p.m.
2 p.m. Exactly. That's better idea. So that yes.
Sorry for my delay again.
It's all right. That's all. $49. Wait, madam. Yes.
Here the appellants, my lord. In fact, my lord, initially
26 persons were placed on a trial before the additional sessions as Bhadrak. Yes. But the appellants in criminal appeal number 273 and 283 are two appeals valid. While in 273, 11 appellants were there, and out of them, appellant.
In the second appeal, there are two accused.
Yes, out
That
of
is,
second, two
accused number
of
17 and 24.
yeah,
No,
No.
out of 26, my lordship, 11 are here. Fine.
valid in criminal appeal number 273 of 94.
There are 11 accused.
11.
11. That is accused number 5, 6, 7, 14, 16, 18, 19, 20, 21, and 23 and 26.
Yes,
They are
they
the
valid.
number.
They out of the appellants, appellant number 2, 4, 10, and 11
Died.
died. Now, other appellants, they are also married. They are reached 80. Almost all them.
What is the offense?
323
341 and 323.
3 years and 1 month simple imprisonment.
Let
But
us
out.
see. What we'll do is probation kori chhad deba.
Lordship, already they have completed because undergone is there.
2 months around they were in custody during trial.
Undergone kori chhad. काम खत्म.
Undergone ki PO Act judge.
कोई डेट करा कर.
PO kori chhad deba, but
PO.
undergone kori.
And with regards to criminal appeal number 283 of 94, two appellants, Purna Das and
Accused number 17 and 24.
Yes.
Yes.
And out of them, there's two valid. One has died with his last marriage, the Lakshmindra Patra.
Died.
Yes. Purna Das has been convicted 304 part 2 and sentenced to undergo RI for
3 years.
3 years.
And he has also gone for first is for 2 months and after conviction, my lordship, 1 month. Total 3 months.
3 months.
Yes.
Kunna.
Kunna.
What was his age? Let us see for Kunna Das.
He was dead.
Kunna.
71 years. No.
Kunna.
Yes.
Undergone ko chhad diyo faltu.
Yes.
71 years, huh?
Valid.
71 years. Undergone period kettila? Kunna
3 months.
3 months. Date is my lordship.
See, the incident is of 90s and all.
Yes, fine.
People unnecessary. Chalo, issue. In the first matter, PO, and second matter, undergone.
May I set the date, my lordship?
Huh?
Date of arrest and
You give it right now. Just now I will give dictation. Otherwise,
now I
these things are burdensome.
yes, ma'am.
I will give you a dictation. In the break, chalo.
My lordship, there are some other matter. There are very offenses. Very my lordship,
Smaller.
smaller.
Huh?
Offenses. It can be disposed of
Which
because 506 only 600 rupees fine.
Which matters? So the councils have to come.
That's the problem with my lordship.
You wherever the smaller offences and smaller sentences are there, please try to contact the lawyer on the other side and tell me, mention, I'll do it. Otherwise, I'll appoint someone and finish it up. That will remain. Don't worry. Don't worry. Madam, no. R. Mahapatra is supposed to come. I told, call R. Mahapatra. There also 1,000 rupees fine. Only 1,000 rupees fine.
R. Mahapatra, Raspberry Mahapatra is
600 rupees fine.
Sir, when there is already the trial courted activity.
59 declared. 59 declared.
That can be.
That Mahapatra. Please contact the other side and tell me so that Thursday I'll finish it up. Huh? I have already heard this is that it can be disposed of. Ask each chapter pastor a short sentence. Opposite side lawyer. He'll give you just.
I'm trying to.
He'll give you the number. What? Yes, madam.
Item 39.
So I'll dispose of these two appeal. I'll just give one. Yes.
Item number 39.
Item number 59 also, my lord, 323, 6 months, my lord.
देखो यार खत्म करो
323 रे कौन हो?
59
Item 59, criminal appeal number 103 of 98.
98 matter Jesse Majan. Unless you do like this, it will never be over.
60 also same, 323 by 149.
That time he was 34.
Guruvar. My lord and friend says good, advanced.
Because
This-
Raj is not there. Actually, he is allowed.
Only you just see undergone
Yes.
period.
Yes,
If it is undergone, sufficiently undergone, otherwise PO.
yes.
We'll finish it up. Otherwise,
Jyoti ki cha argument
there is no
करने
ending.
लगा।
What a nice-
End to it. Yes, madam.
Item number 39. Mm,
Yes.
I'm just a little bit late and item 40 is
It's
late.
all right, no problem. Yes. Ready?
So,
What is the offense?
offense is 324 and only conviction under section 324.
324.
Yes, 1 year conviction.
Sentence?
Sentence 1 year conviction.
1 year. Okay. Undergone period?
Under the-
You will find out one. You will assist. You find out undergone period and tell me Thursday I'll take, because already 5-6 matters are already judgment reserved. I'll go and give dictation otherwise. You find out the undergone period, I'll do. Okay, thank you. What